Lordship, it is an RFA. The parties are ready to go for out of court settlement.
When do you want?
Within 2 or 3 days, Your Lordship.
Pardon?
Within 2 or 3 days.
Thursday.
Here I am to renew my request. Can I plead, my lords, to have it called sometime during this week, any day? I don't insist for it, a particular day, because my client is on a pacemaker. That is the seriousness of the, any day in the week,
Friday.
obliged.
Just see the matters. Should not be beyond the 20 or so. Should stick it to 20 or so. Yeah, coming. Was thinking that if it is up to 25, first list. Instead of 25, if 25 is over, we are taking it.
One submission, madam. Seeking for I sought for a direction,
Yes.
filed IF for direction, seeking reinstatement. During the pendency of the appeal, my lord, they have terminated me. And so for that, my lord, during the pendency of the appeal, they have terminated me. And so for that, my lord, I filed an IF for direction
The relief you are seeking.
for reinstatement, my lord.
Termination.
Yes, my lord.
You may have to challenge the termination now. It's a fresh cause of action.
I am a respondent in this matter.
What was the claim before the learned single judge?
The reinstatement, regularization, my lord, that came to be allowed.
You have to think over. We will have it. But that's now a fresh cause.
But during the pendency of appeal, my lord,
We'll have it. Let's see whatever it's worth. When do you want?
pardon, my lord.
Next week, just make it next
No,
week.
please. Obliged.
My lords. Is he there?
Yes.
Lordship, an FTP matter is posted on Thursday. It's an RFA matter. Can it be listed on before Thursday? Because on Friday it's listed. It's for partition of the property. The commissioner has been appointed. So if Lordship
We
takes
will have it on Thursday. The date is already there now. That is before Friday only?
yeah, before Friday. Any day before Friday.
No. Is it listed on Friday?
No, it's not. Yeah, the matter in the Mysuru court, FTP matter is listed on Friday. Any day before that.
To see the convenient date and get it listed before Friday. Do one thing, you seek an acknowledgement from the other side also. Tell them this is when it is coming. So that it is on record.
I'll copy that.
Yes.
My lords, I request to have it on Friday, my lords. With respect the suit for declaration and injunction, my lords, I have lost the suit before the trial court for admission.
See the this poster only.
Yes, my lord.
Which year?
2019, my lords.
What is
So-
urgency?
My lords, earlier the appeal was dismissed. I have filed an application for restoration. Court has permitted us to complain the office objections. Everything has been complained. It has not been listed afterwards, my lords.
Have it next week. Let's give next week.
Sir, 11-7, acknowledgement ಕೊಡ್ಬೇಕು sir, opposite.
Uh,
You have to acknowledge.
no notice has not been issued as of now.
The memo, sir.
Please, my lord, this one memo.
My lord, we have filed IA for direction. In the trial court, in the plain schedule property, the measurement have mentioned, it is mentioned 1.5 acres, but it is actually 3 acres, my lord. So we have filed the IA for direction to amend the plain schedule property.
We'll have it next week, ma'am. But the only thing is it of this roster?
Yes, my lord.
No date in this?
No, my lord.
Just fine.
My lords,
Sir, opposite mention ಮಾಡಿ ಕೊಡಿ. Opposite ಅವ್ರ ಹತ್ರ receipt acknowledgement ತಗೊಂಡು
the opposite ಅವರಿಗೆ sign ಮಾಡಿಸಿ.
sign ಮಾಡಿಸಿ ನನಗೆ ಕೊಡಿ madam.
My lords, the appeal came to be dismissed for non-payment of court fee, my lord. I paid the court fee and application for recalling the order is filed, my lord, as such the emergency.
ಸ್ಕ್ರೀನ್ ಅನ್ನು ಸ್ವಲ್ಪ ಕೆಳಗಿಡ್ಬೇಕು.
Please, my lord.
ತಾನೇ ಕಾಣಲ್ಲ.
Opposite ಇಲ್ಲ sir.
ಅಲ್ಲಿ
I'm submitting memo of posting.
ಎರಡು ತೆಗಿಬೇಕು.
My lords, this.
Yes.
The land tribunal passed the order, my lord, in against a dead person. One Putranga filed an application, LR application for rent of occupancy rate. It was allowed, though it was filed against a dead person. His LRs were there. And notice was not properly served. So I'm for arguments for admission. Yes.
Is there any date here?
My lord,
Is there any date fixed
date not fixed.
in the appeal?
No, my lord.
Which
Office,
year is-
it is of 2023.
Which is the date, when was the last date?
Last date it was not put. Office objection was there.
Just
Office
give it
objection I
next
have complied.
week. So next.
22-7.
I'm just asking. There's some guy that will list it, taking it.
So
Other side acknowledgement.
Just tell
My
you.
lord, this,
ನಮಗೆ ಕೊಡಿ sir. memo.
What-
My lord, RFA 637 of 20 settlement agide. To report the settlement, kindly list the matter by tomorrow.
Is of this roster?
Yes, ma'am.
Wait, ma'am.
Today's roster is not there.
We take this week or first Monday,
15, sir.
Before 15, any date, my lord.
in July,
Much.
just take an acknowledgement. I'll be
my lord, this one appeal of the writ appeal of the 2022 era. I'm the writ petitioner, my lord. My petition is allowed. I want to put up a construction sort a plan before the Urban Development Authority. They sanctioned the plan before by only one condition, that I have to relinquish certain portion of the road at free of cost. Lord, I grieved that I could not leave the portion of the road free of cost. That endorsement was challenged, the writ petition was allowed, saying that I cannot leave for a free of cost. The Urban Development Authority has to pay me a compensation. The Urban Development Authority has come in the writ appeal. And it's been admitted. My plan sanction has not been, is under,
Filed any application?
no, the application has not been back. The both content. No, like the opposite appellant counsel is also here. If the, on both consent, some here next.
File it. Why there is difficulty in filing an application, it will come, then you mention it.
Please, I shall file an application.
For adjournments. Page number 6, 17-19.
Serial number 17, your lordship. I seek only one day of time, your lordship. I would like to have some clarity on certain documents, your lordships.
Which number?
Serial number 17, only one day of time is required for. I need to have some clarification on certain documents. What are old documents?
We have heard this matter?
No, your lordships.
We have not, but
No.
last time someone had sought time.
That is the appellant in the connected matter, your lordships.
Is Mr. Somashekar appearing?
17,
So did you mention him? Did you tell him?
I'll inform. Prashant, your lordships. MRC Ravi, 17. I'll inform immediately, I'll inform your lordships. 17. Connected matters. Yes. 581, 17.1, your lordship. 17.1, 581. I am appealing for the,
17.1 are
yes, your collected matters. I am appealing for 17.1 for the workman, your lordships.
they say at the request of, but you should have informed Mr.
I'll inform, immediately inform, immediately I'll do it.
At the request of council appearing for
Petition, appellant in the 17.1 matter,
the union,
for the union, your
for
lordships.
the PN Workers Union.
Union.
In both the appeals. Comma, adjourn to, give us in August.
Sub 6(8).
Much okay.
Yes.
Page number 7, 20 to 25.
Your Lordship, I'm appearing for serial number 20, appellant in this case, my lord. The arguing concern senior is having dengue and is admitted, my lord. Kindly have it next week, any date may be fixed, my lord.
I'm for the respondent.
What is the difficulty?
My lord, the senior arguing counsel, he has been tested with dengue. That's the reason, my lord. Kindly have it next week, any date, my lord.
At the request of council, the request for adjournment is made on behalf of the council for the appellant. On the ground that he is unwell, adjourn to.
9(8).
Any date next week, my lord. He'll be ready to argue. Please.
We'll see. Our
Please,
vote.
ma'am.
We have given you 9th of August.
Much obliged, ma'am. Grateful, ma'am.
Page number 8, 26 to 29. For pronouncement, serial number 1, Srinivas. DK Shiranappa.
Prepare for appellant. We are unable to accept the contentions of the learned counsel for the appellant that the improved order suffers from any illegality. Therefore, the appeal is bereft of any merits and therefore the same is dismissed.
Serial number 2, 14% Kiran Babu.
In view of the above discussion, we are of the view that the appeal filed by the appellant is without merit and the same is dismissed.
Three. Sagar. Sagar baby.
This appeal has been listed for being spoken to for the reason that in the order dated 26/6/2024, while we had considered IA numbers 2 to 4 of 2022. But while stating that the applications have been are allowed, we have erroneously mentioned the IAs as IA numbers 1 to 3 of 2023. Henceforth, IA numbers 1 to 3 of 2023 shall be read as IA numbers 2 to 4 of 2022. That's right.
Main appeal memo. Notices to be on main appeal. For LRS, respondent number 7. 782, 5, 6, 7, 8, 2, and 8.
And 8 also.
8 also.
Additionally, we state that the notice shall also be issued to the LRS of respondent number 7 and also to respondent number 8 for the date fixed, that is 8th of August 2024.
Serial number 4, Jagdish. Serial number 4, Jagdish.
The respondent number 5 is still unserved. That fresh notice be issued to the respondent number 5 returnable on the second. Stop.
5-9.
My lord, I appear for the respondent, my lord. The service is complete, my lord, and also, my lord, the objections are filed. I pray, my lord, the matter may be taken up.
Which matter, Mr. Prabhu?
Sir, serial
Five,
number
my lord.
This is serial number 4, sir.
I'm sorry,
Just wait.
extremely sorry.
In the meanwhile, the same 4 also, in the meanwhile, the counsel for the appellant shall also remove the objections as have been notified by the registry. Next meeting.
Serial number 5, SG Bhagavan.
The respondent,
Yes,
the
Service,
you are appearing for,
the appellate,
you are for the appellant.
sub-service was ordered.
The service has been effected through publication, to respondent number 2.
The date may be fixed for hearing.
yes, the matter may be disposed of, my lord. I have filed IA for stay vacating, and objections are also filed. Pleadings are complete. Lordships may fix, my lord, any convenient date and ready to.
The respondent number 2 has been served through publication. And in respect thereof, the counsel for the appellant has filed the paper publication published the daily newspaper Kannada Prabha on record. Full stop. There is no appearance for the respondent number 2.
S. Narayan, respondent number 2.
The list the appeal for hearing on
19-9.
Wait, please.
Please.
Serial number 6, Shri Basuraj.
Appear for appellant. Appear for respondent number 5.
See, there were certain objections that need to be
Yes.
removed.
I will rectify me. I pray for 2 weeks time. I will rectify.
These are granted to comply with the office objections. The date, just give a date.
29-8.
Great.
Serial number 7, Shri Mahesh Uppin.
So the appellants served a copy on respondent number 4 to 6, my lord. I will, during the course of the day, I'll serve it on the ground.
Appellant submits that the office object, the The non-compliance of office objection shall be complied during the course of the day.
Yes, I have to serve it on the government. I'll serve it today.
So re-notify the September.
49. Serial number 8.
I appear for the applicant. May I request for to have this matter on 15. In the meantime, we'll furnish the certificate 15th of this month.
Appear for the respondent.
If the office objections
I have to furnish translated copy. In the meantime, we'll furnish.
be removed within 2 weeks from today, we notify on.
48. Serial number 9.
Let fresh notice be issued for
I'm-
service on.
I'm paid the process today.
For service on respondent file.
8.
I think capital A2, capital G,
Please.
returnable on.
10-9. Serial number 10.
And please show me.
My lords, I am appearing for the appellant in this matter, my lords. My lords, I am appearing for the appellant at serial number 10, my lords.
Yes.
My lords, on the last occasion, myself and the contesting respondent.
Yes, one.
Yes, my lords.
Yes.
Serial number 10.
My lords, I am appearing for the appellant in serial number 10, my lords. My lords, on the last occasion, myself and the contesting respondent counsel had submitted that the matter may kindly be listed for final hearing. Since this court has already heard us on the stay application as an already granted an interim order, my lords. On the last occasion, my lords,
Yes.
my lords, the matter may kindly be listed for final hearing. May I adjourn by 2 weeks, my lords, for final hearing?
Just 1 minute. And where is the file? Just give the file. Who is appearing for the respondent?
Minutes, I appear
Hello?
for respondent number 5 minutes.
You are appearing for the?
Serial number 10.
My lords, I am appearing for the appellant in this matter, my lords.
The request of counsel for the appellant, we notify.
5-9.
My lords, my one request, humble request, my lord, this may be posted for final hearing, my lords.
Fine, you are for the
My lords,
Respondent number 5 minutes.
for filing.
my lords, the interim order may kindly be extended, my lords.
Interim order, if any, to be is extended till the next date of hearing.
Obliged.
Obliged, my lords.
Serial number 11.
Appear for the applicant. No. Happened, my lord, there are 22 persons have filed writ petition. Writ petition was allowed and the alternative accommodation was granted. Our contention is alternative accommodation are suited, not suitable, but it was not let out from since 2007. That was a vacant land and now they wanted to construct it. And it is not feasible also, my lord. We were
There is an issue of court fee.
Court fee was 22 persons have filed writ petition. Now only 12 persons have filed. Now in any of the decision below, one court fee is sufficient, I think. So. If otherwise I have to pay another 11 sets below.
How many you had filed in the writ petition?
Writ petition, 22 persons have filed.
So today there are 12.
12 only.
So 12 in any case, you have to file it.
Yes, I will pay out, that I will pay.
That needs to
11,
be-
11 set I have to pay. I will pay. Because in the decision, I decided one order, one set is sufficient.
Now, what is this instruction you are pointing out?
Now,
What does that say?
say it is one, if it one order is to challenge, one set of court is sufficient. Anyhow, I had paid, I will pay it. 11,000, because if I pay 22,000, 2,200.
Yeah, but
In writ petition, I had paid 22 sets I have paid.
So number of the writ petitioners.
Petitioners. Now it is only 12.
No,
If
sir.
your lordship directs me to pay to 11.
the same logic only you have to file. this.
That judgment I have not pointed out there because it was an urgent matter. I did not point out. Anyhow, I pay 1,100 I pay me lord. Because otherwise they will not accept 2,100 I have to pay. Now only 12 petitioners have. paid.
Whatever who have come in appeal, they have to pay.
12 persons have come in appeal. Yes, sir.
Well, you should pay. But well, you know, you will say, total exemption, except only 100.
Learned counsel for the appellant submits that the objection regarding court fee shall be removed within 1 week.
I have to pay 2,100 there. That's your lordship has to pass 12 persons, that 1,100 now balance. Now 22 persons have not appealed against. It is only 11 persons, 12 persons.
It's applicable for the number of colors who are opposed.
As applicable for the appellants who have approached this court. Okay?
Yes.
Within 1 week, full stop, re-notify on. Oblige.
For appealant for the respondent number 2 and 3, copy served now.
That 2 weeks time might be granted for, my lord, for rejoinder,
For,
for filing a rejoinder. my lord.
you filed the objections, ma'am?
Copy so
The
please served.
objections,
I just
you
know
got
it's
the
served.
copy of the
Yeah,
objection?
I've received the copy.
The objections have been filed by the respondent number
2 and 3.
2 and 3. The learner counsel for the appellant seeks and is allowed how much time?
2 weeks time. my lord.
2 weeks to file rejoinder to the objections. List on.
Much obliged.
Yes, you want to withdraw this?
Withdraw this appeal. Please.
You appear
Unconditional.
for?
I'm for respondent number 23.
I'm for respondent number 1 and 2, my lords.
1.
These are similar appeal. This is argument sort of representation. But he wants to withdraw it.
Where is the direction in your matter? Where is the dismissal of the writ petition?
My writ petition was neither dismissed nor allowed, but it was tagged along with the bunch of cases, which were the other cases were.
Where is that finding of yours?
No, there is no finding in the writ petition, in the entire writ petition, there is no finding in respect of this petition. A common order came to be passed, your lordship. The other batches were pertaining to the acquisition proceedings in respect of Arkavati layout.
That's right.
Whereas in this writ petition, I had not challenged the acquisition proceedings. On the other hand, I had challenged the order passed by SLAO. I had approached the SLAO for seeking to grant 4060 scheme, the compensation under 4060 scheme. The SLO directed us to approach the commissioner. Instead of approaching the commissioner, we filed writ petition. But we, at the time of clubbing this matter, it was fault on the part of the petitioner that we did not bring to the notice of the honorable single judge that this matter does not pertain to the acquisition proceedings. So however, it was clubbed and a common order came to be passed. There the acquisition proceedings was upheld and a committee was constituted, and those petitioners, the landowners in that who has challenged the acquisition proceedings, were asked to approach the committee. But since no order was passed and since my writ petition did not pertain to the acquisition proceedings, but however, since a common order was passed,
But there
I
is,
sought for
there is any observation also in the impugned order?
nothing. No, I sought for review, but however, review also came to be dismissed. Thereafter, I filed this.
What happened to review?
Review came to be dismissed, directing me to.
Challenge the review order here.
I had challenged, 2 appeals were filed, but 1 appeal came to be dismissed by this honorable court, such this appeal is filed. This appeal is sufficient and that appeal came to be dismissed.
No, tell us one thing. Did you challenge the review?
No, review also had challenge, but that appeal came to be dismissed by this honorable court. Since this appeal is filed against the original order, this is sufficient and notice were issued in this appeal. Against the reviewer, in the review, I was also directed to approach the committee. Thereafter, the review came to be.
Do review say so?
I have said so, and I approached the committee thereafterwards. But committee has passed an order. So I have produced that along with the additional documents. The committee has observed that the committee cannot go into the question which is arised in this writ petition, since the writ petition does not pertain to acquisition proceedings, and thus it has dismissed my application. Thereafter, I have filed this appeal.
Thereafter, you filed this appeal. But why did you file this appeal?
Even filing of writ petition itself was wrong, your lordships. I would not have.
1 wrong, 2 wrong, but why 3rd wrong?
No, because since I was asked to approach the committee, for that I filed this writ appeal. So because
But you simpliciter, you want to withdraw it?
Simpliciter. Because original order by the SLO was.
So we will say so it doesn't survive. We'll say simply, the learned counsel for the appellant has filed a memo for withdrawal. Full stop. He states that he wants to withdraw the writ appeal, dismiss as withdrawn.
Please, much obliged.
Pray for a week's time, my lord. Respondent number 8, 11 to 13, my lord, served and unrepresented before single judge, my lord. Insofar it relates to 5 to
Want
7.
to serve them first?
I'll serve them.
Let
Week's
notice
time.
be, respondent R5 to R8 and R11 and R13 are still unserved. Let fresh notice be issued for service on the said respondents returnable on.
Let 5 to 7, my lord, the council represented Yogesh D. Nayak. I will take out, my lord, the institution he is representing for.
See, you should serve the parties.
Please.
Better would be serve the parties. Suppose the council say he doesn't have any.
Bayappa, my lord, planning authority, Yogesh D. Nayak is representing. I will take out notice to Nayak.
We will say you serve on them.
Please.
Let a fresh notice be issued to respondent 3 and 4. Returnable on.
My lord, it is pertaining to compliance of office objections. It is pertaining to compliance of office objections.
This shows that.
Last time.
Pending. Pending consideration.
pending consideration of IA 1 of 2024, the office objections be rectified within 3 weeks.
Okay. All this.
List on.
17 adjourned, 18 Rahul Reddy.
Week's time may be granted in this case, Mr.
No time.
The counsel, Mr. Rahul Reddy, is not present.
It's all right, please.
Case 2 to day after tomorrow, my lords. Today he cannot be present. Really sorry, my apologies.
All right, no, not like this, please.
Due to his health issue, he could not be present.
Pardon?
Due to his health issue, he could not be present.
Who?
Mr. Counsel Rahul S. Reddy, my lords.
See, he was to file that condonation of delay in bringing the deceased, loss of the deceased on record.
If I'm not wrong, my lords, the IAs are still
Knowing
pending.
about that delay now.
Well, the IAs are still
Is it
pending.
necessary that we have to calculate it and tell you?
I will verify it, my lords.
Isn't it?
I have no
When
instructions.
you have filed an application to
Condonation of delay.
bring the LRs of the respondent number 2, you were knowing that there is a delay. And why did you not file? Is it not a prima facie
Yes, my lords, there is.
error which you have committed knowingly?
I'll go through my, I have no instructions.
Why you
I will
grant
rectify
the
it, my
time?
lords, in the. I'll verify and rectify it, my lords. I'll instruct him also.
Certification.
It should be setting aside of abatement.
Yes, my lords.
That's also not.
As per this records, my
The-
lords, on 11/1/23.
The Leonard, so-and-so appears for Mr. Rahul S. Reddy, advocate for the appellant. Seeks and is allowed some time to some time to file an application seeking condonation of delay in bringing the LRs of deceased respondent number 2 on record. At his request, re-notify, give September.
Obligement.
For the respondent in this matter.
Yes. He wanted to take certain instructions.
This, I think a question that was posed by Melons is, under the rules, if it says within 5 years, you have to construct a residential house on the site, whether non-compliance of it would completely will go to the root of it, and whether the allotment itself is liable to be cancelled. And therefore, the question of penalty, etc., may be redundant. Was the question? Is that, do I understand that question correctly? So, if I can answer that question straight away. This is a subject matter, that's been that's covered by a few judgments of our court. To say that, when we read Rule 19, the requirement of Rule 19.
Just give the act.
May I request Malad to kindly go straight to rule number 6, Malad. 19 subclause 6, sorry.
Rule
19 subclause 6. The allottee shall construct a building within a period of, may I read it, Malad? 19.
Page 135.
ನಿವೇಶನಗಳ ಹಂಚಿಕೆ.
ಅದೇ ಕನ್ನಡದಲ್ಲಿ
ಹೌದು.
ಕೇಳಿ
Page
Malad,
135.
one small difficulty we have, Malad, notwithstanding what Article 348 says. This is a case in which the rules have been made partly in Kannada and partly in English. So we will see So there is no complete English text of the rules. And my lord, amendments have been incorporated into the rules in Kannada. So
We have English now.
my lord,
We have English part of it also.
the
Let's-
English part of it is also there.
Let's read.
My lord, 19(6), my lord. The allottee shall construct a building within a period of 5 years from the date of execution of the agreement, or such extended period as the authority may, in any specified case, by written order permit. If the building is not constructed within the said period of allotment, may after reasonable notice to the allottee, be cancelled. The agreement revoked, the lease determined, and the allottee evicted from the site by the authority after forfeiting 12.5% of the value of the site paid by the allottee. The authority shall refund the balance to the allottee. So, my lord, the authority no doubt has a discretion under Rule 6. If I fail to construct, to do two things. One, they could extend the time, or my lord, the second is that they could issue notice to me and thereafter cancel it and return retain 12% return balance, etc. Now, my lord, may kindly look at Rule 7. Rule 7.1. On the expiry of a period of 10 years from the date of lease sale agreement, and if the allotment has not been cancelled, or the lease has not been determined in accordance with these rules or the terms of the agreement, the authority shall, by notice, call upon the allottee to get the sale deed of the site executed at its own cost within the time specified in the said notice. And my lord, kindly also look at subclause 2. If the allottee fails, now my lord, if they issue notice to me to get the sale deed done, I fail to do so. If the allottee fails to get the sale deed executed within the time specified, the authority shall itself execute the same and recover the cost and other charges, if any, incidental thereto from the allottee. So, my lord, the mandate under Rule 7, my lord, is that at the expiry of 10 years, my lord, if they have not exercised the option of cancelling the allotment that has been given, then, my lord, they have to necessarily execute the sale deed. Now, my lord, I would put this on two principles. Firstly, my lord, when under Rule subclause 6, Rule 19 subclause 6, the authority is given the option of cancelling the allotment if I fail to construct, my lord, they have to exercise that option also within a reasonable time. My lord, normally, my lord, there are enough number of judgments to say what would be reasonable time in these circumstances. But in this case, the rule itself says what that reasonable time is. The rule itself says that the reasonable time is 10 years and not beyond. And not, so therefore, my lord, so the exercise of that right to allot, my lord, has to be exercised within that time period. If that had not been done, like in this case, my lord, the allotment was made to my father-in-law. He passed away. And my lord, thereafter, my lord, my mother-in-law and my husband became owners. Mother-in-law passed away. Now husband's passed away. It's come to the widow. And now the question is, in the hands of the widow, who is the petitioner, what needs to be done? 1991 allotment, my lord, ought to have been cancelled before 2001. And my lord, today, question, when we go to them for the sale, for the registration of sale deed, they say, no, I must pay 6.5 lakh rupees to them for the purpose of them executing the sale deed in my favor. Whereas the mandate in 7.2 was, even if I had not gone, they should have themselves registered the property in my name, which was the mandate under 19.7 subclause 2.
See, that presupposes now that you have to make construction for sale deed.
No, I have to construct. If I don't construct, the consequences. But after 10 years, my lord, the construction or no construction in my respective
How can that be? Then see what is the mischief of the rule then? No one will construct for 10 years. They will say, okay, after 10 years, in any case, there is a sale deed coming in my favor.
My lord,
wait better.
My lord, if that is, my lord, may kindly see if that's the mischief that is sought to be done, what the contention of the other side is. No, you pay me 6.5 lakh rupees, which is what I am now saying you should pay to me by virtue of, and kindly see in this multiple things, my lord, there are 10-year period during which under clause 20, there's a non-alienation clause, which means I can't sell the property within that period. Under clause 19, I am required to construct. The two obligations that are there under the rules. Now, my lord, there are instances where people have sold. Even that does not go to the root of anything. My lord, all that they say is, at the end of this period, when you come to me for sale deed, I will collect so and so charges, which is what is provided under the rule, under Rule 20. So, the mandate was not that if for non-compliance of 19 subclause 6 in all cases, my lord, it will lead to invalidity
ಯಾವ
of,
matter ಗೆ?
of the allotment. It gave the authority a
Admission
discretion.
ಇನ್ನೂ ನೋಟಿಸೇ ಮಾಡಿಲ್ವಲ್ಲ
the
ಅವರು
discretion-
ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ ನಾನು ಬೇರೆ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಹೆಲ್ಡ್ ಅಪ್ ಆಗಿದೆ.
The discretion, my lord, would extend to extend the time period. They could extend time, which is what is contained in Rule 6. So when we read Rule 19 subclause 6, it is entirely at the discretion of the authorities. Now, my lord, if they choose not to exercise that discretion, my lord, it is completely within their province and the power and authorities contained in 19 subclause 6, and we can't find fault with that. Would be my respectful submission. Now, my lord,
So when 19 presupposes a construction for execution of the sale deed. 19.6.
Yes, madam.
It contemplates the construction being made
Yes.
for execution of a sale deed.
Yes, my lord, 19.6 in my respectful submission doesn't talk about execution of sale deed. 19.7 talks about sale deed.
19.6, the allotee shall construct a building
Building
within a
within
period of 5
5
years from the
years.
date of execution of the ignore such extended period. Specify the day. If the building is not
constructed
considered.
in said period, the allotment may after reasonable notice the allotee be cancelled, the agreement revoked, the lease determined, and the allotee evicted from the site by the authority after forfeiting 12.5% of the value of the site paid by the allotee.
So,
The
but-
authority shall refund the balance. Now, 19.7 will be the sale deed.
No, 19.6, tell us one thing. Suppose you make a construction within 5 years under 19.6.
Yes.
After 10 years, there is a sale deed comes in.
Yes.
It has to be that way only, because there has to be some positive to the fact that you have made a construction on that.
My lord, construction of it, my lord, is the requirement of executing a sale deed in my favor, my lord, is not entirely in 19. 19 is talking about the conditions of lease and where, because otherwise, my lord, the lease deed itself by its terms results in the execution of sale deed in my favor. So 19 subclause 6 is talking about my obligation to construct. And my lord, this has been subject matter of at least 2 judgments of this honorable court.
You sure that?
My lord.
But on facts, I think those would be on facts which we are concerned here.
I'll point out. Now, can I request my lord to kindly look at first the judgment of the learned single judge, my lord, in 2022.
Only Mr. Kumar, only to clarify it, I hope you have been told what is being argued. Is that intent is that even after 10 years, that sale deed, if you have not executed, if you have not made a construction, then the sale deed can only be executed by imposing this kind of a condition. That what you have done, claiming 6.5 lakhs. That's right. Now, having claimed the 6.5 lakhs, if they pay, you will execute the sale deed.
I have paid under protest, they have executed sale deed in my
They
favor.
have executed the sale. Now, what is your case is refund of that amount.
Yes.
Which is being in a way allowed
My lord.
and which is under challenge here.
Yes. So their contention, my lord, was under Rule 20, they have introduced a subclause 3. My lord, I point that, kindly look at the contention. Under Rule 20, my lord, under subclause 3 of Rule 20, my lord, there have been 3 additions that have been made, by virtue of which they say a penalty can be imposed. Now, my lord, kindly see Rule 20 for a minute. Rule 20 talks about, my lord, another condition. I'll read Rule 21. The allotee shall not alienate the site within the lease period for 10 years, except mortgaging the site in favor of the government of India or state government or any financial institution for the purpose of securing a loan for constructing building. So, Rule 20 subclause 1 is against non-alienation. It says I can't alienate except a mortgage of that limited right that is contained there. 2, if the site is alienated within the lease period, except for the purpose as specified in Rule 1, the authority shall, after due notice to the lessee, shall cancel the allotment, resume the site, and forfeit the amount paid by the lessee. So if they alienate, now my lord, can you see the difference in language? It shall. My lord, the mandate in 20 subclause 2 is it shall cancel. Then my lord, in Rule 20 subclause 3. Notwithstanding anything contained in the above rule, if the lessee applies for reasons beyond his control or reasons of his insolvency or impecuniosities to sell the site or the site with the building constructed thereupon, the authority may, with the previous approval of the government, either A, require him to surrender the site whereupon no building is constructed. The authority shall, after surrender, shall pay the lessee the siteal value with interest at the rate of 12% per annum. So, my lord, kindly see here, only if he makes that application, is entitled 12% return. Then kindly see B, where the building is constructed on the site, so allotted, the authority shall permit him to sell. So if he makes an application, makes out a ground, then as far as alienation is concerned, 2 things can happen as per sub-rule 3. One is, if there's no construction, there is no question of extending time. If there is a construction, then the court may, the authorities may extend it. Now, my lord, to that, 3 sub-clauses have been added. Parantu, my lord, that would be the equivalent of provided in English. So the first of them, my lord, is talking about a sale. My lord, can I just pass on an English translation of these 3 clauses?
This has been added in 2012.
Yes. My allotment is in 1991. Now, I'm just giving an English translation of these provisos. Provided that where an allottee of a site allotted under the Karnataka Urban Development Authority Sites Rules 1991 alienates the same either before or after the construction of a building thereon, within a period of 10 years, the authority shall execute a sale deed after collecting from the purchaser a penalty of a sum equivalent to 50% of the guideline value fixed by the government from time to time.
So that's not the position here.
That's not the position. Then B, where I have not sold the site. My site is still with me. I have not sold it to anybody. Where an allottee of a site allotted under the Karnataka Urban Development Authority's Rules 1991 alienates the site after completion of the lease period of 10 years, whether with or without construction of a building thereon, but before the authority has executed a sale deed in his or her favor, the authority shall execute a sale deed after constructing.
This is the same. We are not concerned.
We're not concerned. Then C, my lord. But according to me, even C doesn't apply to us, but I'll just read it because the other side thinks that C applies. Where the allottee of a site allotted between the years 2001 and 2005, that is between the commencement of the Karnataka Urban Development Authority's allotment of site rules of 1991 as amended by government notification so and so, and the Karnataka Urban Development Authorities Act Sites Allotment Rules 1991 as amended by notification so and so, have not secured a sale deed of the site. Now, my lord, kindly see, in subclause 2, there is no reference to alienation. It simply says, have not secured a sale deed of the site in his or her favor. The authority shall execute a sale deed after collecting from the allottee a penalty equivalent to 25% of the guideline value fixed by the government from time to time. So it is their case that under this proviso C, which does not talk about alienation, but it talks about where no sale deed has been executed, they say this is a penalty that is payable and therefore seek to apply it.
But no third-party purchasers have come.
No third-party
There is no purchase because there is no alienation, no purchaser.
Yes. Now, my lord,
this is peculiar to 2001, 2005.
Yes. Firstly, my lord, this is 2001 to 2005. Secondly, my lord, this is a proviso that is added under
20.
Under 20. It is not contained in 19. So we will have, in my respectful submission, we will have to read it as being part of the main clause. It cannot be a proviso to the rule, cannot be read in respect of another rule without reference to the rule for which it is a proviso. So my lord, these contentions were raised before the court below. My lord, that their contention was, no, I am entitled to levy 6.5 lakhs because I am entitled to do so under 3 subclause C, 3 proviso C. And therefore, I have imposed this. The contention that we had advanced was, firstly, this rule, even if a plain reading of this rule, it applies only to the allotments between 2001 and 2005. It does not apply to allotments that happened prior to 2001. And as far as the proviso is concerned, we said it was our contention. This proviso does not apply to Rule 19. And under Rule 19, my lord, once the 10-year period comes to an end, my lord, the authority has to execute a sale deed, and there is no provision for imposing a penalty under it. And when there is no provision for penalty, my lord, without the imposition of a penalty, my lord, the authority cannot seek to levy such penalty.
But tell us one thing, Mr. Kumar, how would you reconcile 19.6 and 19.7? 19.6 also contemplates if you don't make construction, get the sale, very well. You said there is no provision of sale deed there. You don't make any construction. After 10th year, they will execute the sale deed. That's their stand.
Yes.
They can determine the lease also if you don't make the construction.
Not after 10 years.
That's right.
Yes.
So within 10 years, if they don't make, you don't make construction, they can determine the lease.
Yes.
Very right. Now that's what we are, you have to now assist us on this thing. That's what we are saying, that can you be a better placed after 10 years? If you don't make construction, they can't cancel the lease.
Yes.
But they have to necessarily execute the
sale
deed without any construction. How would you answer this? Because that's what really is the.
That's what's troubling, my lord. Can we see under Rule 19 subclause 6? It is not that in all cases it will automatically. The Rule 19 subclause 6 does not say if you don't construct, your allotment will automatically go. No. Unlike, my lord, very different language used in 20 subclause 2, for example. The authority is left with no option. It is in fact, the cancellation and resumption of site is a mandatory requirement under 20 subclause 2. Whereas under 19 subclause 6, the authority is vested with the discretion to choose whether they want to cancel it or not. Essentially, my lord, they will look at what are the circumstances. Was a person going through difficulties?
Just to interrupt you, what is being argued is in 19.7, you will read construction to be made. That's being argued.
Yes.
Under 19.7. So you must.
I will answer that. But, my lord, can you look at the construct of Rule 6 first? Because under Rule 6, my lord, for example, if the notice had been issued to my father-in-law, he would have gone to the authority, and he had complete, the rule provides that I can satisfy the authority of my difficulties, etc. They can extend time. My lord, as far as, so the mandate that is contained under Rule 6 is not cast in stone. The authority is vested with the discretion to on a case-to-case basis, my lord, to decide what they want to do as far as the allotment is concerned. Now, my lord, when we come to Rule 7, the mandate under Rule 7, my lord, is contrary. It says, on the expiry of a period of 10 years from the date of the lease cum sale agreement, if the allotment has not been cancelled or the lease has not been determined in accordance with these rules or the terms of the agreement, the authority shall by notice call upon the allottee to get the sale deed and the sale deed of the site executed at his own cost within the time specified in the notice. So, my lord, kindly see, at the end of 10 years, they don't even talk about curing a defect in Rule 6. So it is the limitation that is set in 6 is something that has to be done within that period of 10 years. Post that, my lord, the mandate of Rule 7 is mandatory. Now, my lord, kindly. One recent judgment of
So what you possibly, subject to what he says,
yes,
you can argue still 19.7.2 also by relying upon 19.7.2 also.
Yes.
Even you don't come forward.
But they have to do it.
The obligation is on them to get it.
Keep the same.
And it doesn't put any precondition of construction. But he is reading into that.
Yes. Now, my lord, kindly look at this one judgment, a judgment of this honorable court in 2022. On page 2. On 17 September 93, the petitioner was allotted a site bearing number so and so. This is Belgaum, in Belgaum. on 4/7/94, a lease cum sale agreement was executed and registered by the respondent in favor of the petitioner. Rule 19(6) of the Karnataka Urban Development Authority's allotment of sites rules of 1991 mandate that the allottee should construct a building within a period of 5 years from the date of execution of the agreement, or such extended period as the authority may specify by way of a written order. The rule stipulates that if the building is not constructed within a period of 5 years, the allotment may be cancelled after reasonable notice to the allottee, and also the agreement can also be revoked and the lease determined, and the allottee can be evicted from the site. The rules also stipulate that thereafter the authority can forfeit 12.5% of the value of the site paid by the allottee and refund the balance to the allottee. Thus, sub-rule 6 of 19 confers on the power on the authority to revoke the lease cum sale agreement if the building is not constructed within a period of 5 years, with the stipulation that on this revocation, 12.5% of the value of the site paid by the allottee would be forfeited and balance would be refunded to the allottee. In the present case, it is the case of the authority that they had issued a notice on 22/12/2005. Now, my lord, kindly see allotment in 94, notice on 22/12/2005. That's 11 years after the execution of the agreement of sale. And thereafter, since the notice was returned as unserved, they proceeded to pass the order cancelling the site allotted to the petitioner. Sub-rule 7 of Rule 19 reads as under. As could be.
They could have cancelled it.
Yes, they sought to cancel it. In that case, they sought to cancel it.
No, this proposed action of cancelling is under which rule?
Well, that was the subject matter of this repetition. We'll see
But
that.
will it fall under 19(7)?
No.
19(6), 19(6) or 19(7)?
19(7) only.
19(7).
Yes, paragraph number
No, my lord,
5. Para 5.
Para?
Para 5 of the order, my lords.
No, that's right, but
No, Manoj, that it will be an action only under 19(6) would be my respect submission. But in any event, let us see what happens.
no, but this happens after 11 years.
Yes.
After 11 years. So, Manoj, in my case, now if they today say initiate proceedings to cancel allotment, I would be on the same situation as this, which is not the case. Here they've executed the sale deed in my favor. But if they had done so, but to understand 19(6) and 19(7), Manoj, kindly bear with me.
Only one, Mr. Kumar, reading this case.
Yes.
What has been done is 11. Now, that is what we are asking. Does the rules 19(6), 19(7), a reading of both contemplates a cancellation after 10 years? No, it doesn't. No?
No, it does not. Cancellation is contemplated when I fail to build. If the violation is of my building on the site, then, my lord, the cancellation is only under 19(6). So they issue a notice to me. They're not satisfied with the reasons I give them. Then they may cancel it. But there's a set time limit of 10 years. Quite different from 20 if I sell it during the alienation period.
Rule 6 applies between 5 to 10 years.
Between 5 to 10 years.
Up to 5 years, you do not construct.
Yes. I have time up to 5 years to construct.
5 years. Then between 5 to 10 years, if you have not constructed, they have to issue a notice for cancellation.
Yes. And they're not happy with my explanation and reasons that I give, then they can cancel.
They can cancel it, or they may extend the time.
Extend the time.
So that is permitted.
Yes.
Beyond 10 years, then rule 7 applies.
7
Sub-rule 7 applies.
Yes.
But no
But
cancellation.
this is very different from 20 subclause 2.
But rule 7, it doesn't contemplate cancellation.
Rule 7 does not contemplate cancellation.
That means they forfeit the right of cancellation of the allotment
At the end of 10 years. So, Manoj, now if Manoj looks at this, the learned single judge is of the same view, Manoj. Kindly look at this. I'll continue reading at para 6 on page 4. As could be seen from the above sub-rule, on the expiry of 10 years, the allotment has not been cancelled or the lease has not been determined, the authority is required by notice to call upon the allottee to get the sale deed of the site executed at his own cost within the time stipulated. In fact, subclause 2 of Rule 7 goes on to state that if the allottee fails to get the sale executed within the time stipulated by the authority shall execute the sale deed and recover the cost and other charges, if any, incidental thereto from the allottee. A plain reading of subsection 7 of the rule indicates that on the expiry of 10 years, the authority is obligated to execute a sale deed in favor of the allottee in the event the lease cum sale agreement or allotment has not been cancelled. This indicates that the lease cum sale agreement and the allotment can be cancelled only within the period of 10 years and not after 10 years. In other words, the authority is reserved the right to cancel the allotment only during the period of 10 years and not beyond that. And my lord, in this case, my lord, we are not concerned with an attempt to cancel the sale deed because it is nobody's case. They have also not issued notice. They are not trying to cancel my sale deed. In fact, they've executed the sale deed in my favor. The only question that arises in this case is, my lord, can they levy a penalty or not levy a penalty? But when the rules prescribe that penalty, now if even assuming the proviso to Rule 20 was to apply, that rule only authorizes them to levy a penalty for those who were allotted between 2001 and 2005. Because after 2005, my lord, the provisos 1 and A and B will apply. So therefore, the question is, in the instant case, my lord, I am a person who was allottee in 1991. No rule has been made to impose any penalty upon me. And my lord, in my respectful submission, even if they had made a rule and it was sought to be given it would be giving it a retrospective effect. That would require another consideration. But in any event, my lord, in the instant case, my lord, my respectful submission is that they have no authority to impose any penalty. And they are trying to justify the authority to impose penalty by reference to 20 subclause 3 subclause C.
But they say on clarification also. They rely upon certain clarification issued.
That also has been gone into because that is not even a rule.
That's not even a rule, you're right.
That whether penalty can be imposed only by statute. Statute has to make a prescription for it. Here is a case where they have provided for some rules which impose some penalties. Now, a reading of the rule also does not prescribe come there. Third, the next question is, can they then say, no, it's not contained in the act, it is not contained in the rules, but I have issued a clarification, so pay penalty in accordance with that. That, in my respectful submission, would be beyond their jurisdiction. Can I request now to kindly look at
You
paragraph
said
9?
there are any other judgment you want to rely upon?
Yes. There is there's a division bench judgment of this honorable court, which also seems to follow the same a short judgment, will not quickly read it. The intra-court appeal is by the Kalburgi Union Development Authority, calling in question the writ court's order and so filed by the first respondent. The contempt proceedings are filed, etc. I'll go to para 2. It is undisputed that the Urban Development Authority has allotted a plot bearing number 309, measuring so and so in the year 2009. And the first respondent has deposited the entire allotment price way back in the year 2012. The first respondent has filed this writ petition contending that, amongst others, that notwithstanding the aforesaid circumstances, the impugned endorsement dated so and so is issued, informing him that the allotment which was made in 2009 is cancelled. The writ court, while considering the first respondent's grievance as against this endorsement, has allowed a writ petition quashing the same in the light of decision of the coordinate bench of this court in so and so. Then it is submitted that in unison that the first respondent, after the writ court's order, has remitted rupees 1 lakh and so. Sri Mahesh, the learned counsel for so and so, submits that because of the writ court has disposed of writ petition in terms of so and so, which is disposed of confirming order of 31/7/2013 in so and so, it was incumbent upon the first respondent to deposit such amount. On the next page, Narendra Reddy, the learned counsel for the Urban Development Authority, submits that the authority is aggrieved by the writ court's order dated so and so, because the writ court has failed to consider the first respondent's liability to pay interest in the event of allotment. Can I request, can you look at the last 3 lines on para 5?
Yes.
Rule 19 of the allotment of site rules must also opine that the Urban Development Authority is not entirely divested of the power to cancel allotment, and such jurisdiction can be exercised after lease cum sale agreement is executed if there is a failure to comply with the terms of the lease within the timelines contemplated under Rule 19 subclause 6. If the So if the Urban Development Authority cannot source its jurisdiction to the provisions of the allotment of site rules to cancel the allotment, it cannot be aggrieved by the writ court's order, so and so. So here also was a case where they upheld the time limit that was contained in Rule 1966. Now, my lord, the principle that we see, my lord, there are parallels to this, my lord, both under the PTCL law and, my lord, even under the Land Acquisition Act. There are judgments to say where the authority is vested with power, etc., to do a certain thing, and no time limit is fixed. It would be my case to say that under 1906, a time limit is fixed. But if no time limit was fixed, my lord, it is not an endless thing. I mean, my lord, if in 1991 allotment, 2001, my lord, it fructifies the period of during which 1906 comes to an end. My lord, what ought to have been done within 5 years from the date of allotment? Can it be done in 2024? Is the question I ask. My lord, to which, my lord, the principle in law is that where the statute imposes a particular responsibility on an authority, it should be exercised within a reasonable time. In my respectful submission, that reasonable time has been exercised, is prescribed today in the rules itself, because 1906 itself says so. And not having exercised that discretion within that discretion is not available to them thereafter. Now, there are few authorities on that subject, but I may not.
Yes.
Let's
See, what is being argued is, you have a power under 1906. You can exercise, cancel it, determine the lease. If you don't do it within 10 years, after 10 years, you loses the right to seek construction. As a mandatory act, you will lose your right to ask the allottee to make construction. But you necessarily have to execute the lease deed in terms of 1972. If he doesn't, then the obligation is on yours. If that being the position, then you can't, even as a penalty, without there being a stipulation in the statute, by way of an administrative instruction, cannot do it. The penalty need to be provision under the statute, like you have done in the case of, but you have, you have incorporated for 2001, 2005, a specific clause. That is missing with regard to allotments made or the lease executed between 1991 and thereafter. What do you have to say?
I'll answer this for minutes. Let the allotment, construction within 5 years, execution of sale deed after expiry of 10 years. If the construction is made, there is no ambiguity, there is no dispute. That is the position of allotments. There is an allotment. There is no construction within 5 years. There is no construction even within 10 years. Then after expiry of 10 years, if a request is made for execution of sale deed, prior to 2013 amendment and the consequential communication by the government, the authority was not empowered to execute the sale deed in respect of a vacant site. Is my respect submission. It is but for this amendment and the consequential, the continued instructions by the government, the application of the petitioner was considered for execution of sale deed. If there was no amendment or there was no instruction.
Amendment is for 2001-5.
Please notes, 2001 to 2005. If the amendment is straight away applied, the petitioner's case would not come within the purview of 2001 to 2005.
Not be considered.
It is because of the clarification we obtained, we could consider their case for execution of the sale deed. Is my respectful submission. But one aspect which is not argued is that the allottee and the authority are bound by the conditions of lease also. It is a contract between the parties. That the lease deed specifically stipulates then only upon the compliance of the conditions of lease, and if there is no breach thereof, then the authority is obliged to execute the sale deed upon expiry of 10 years. The clauses contained in the lease cum sale agreement is part of the rule only. Kindly see Form 1 attached to rule allotment rules. Form 3, I'm sorry, page 141 of the book.
Since tell us one thing, were you not within your rights to take action if they have not constructed?
Like that, my,
Once you miss the bus, then that obligation under 1719, that's rule 7, 1 or 2 would come in.
but I would reiterate once again what I have argued day before yesterday. That the entire rule and the object behind it will have to be taken into consideration. There are ambiguities. I don't say no. In framing rule 19.6 and 7, there are certain amount of ambiguities, but your lordships will have to interpret in such a way the very object of the enactment, allotment of site will have to be there too, and that we have to see that the object would be is achieved. Object is achieved. Not technically saying that immediately after 10 years, if there is no cancellation, I'm entitled for sale deed. Not for the allotment is made at a subsidized rate only to see that they should have a roof on their head. It is not for selling multiple times to different purchasers. What happens is if we execute the sale deed immediately after 10 years, it would amount to encouraging the real estate activities only. It would not achieve the object of the act and the rules. Kindly see Form 3, which is a part of the rules. Therefore, this has a statutory force. Is my respectful submission. Form 3 lease cum sale agreement. It is under Rule 19 only.
Form 3 was introduced in 2005, so it was not the form that was used in.
No, this is amended Form 3. It was also there earlier.
Was there earlier?
The clauses contained in Form 3 are identical to the lease cum sale agreement entered into between the petitioner and the authority. Kindly see class 3 and class 12. These two clauses are contained in the lease cum sale agreement entered into between the petitioner and the authority. Specific rules are Rule 3 and Rule 12. Now kindly come to the lease cum sale agreement between the parties. It is at page 58. English translation is at page 63. Lordships have seen these clauses the day before yesterday also. Page 68. So, page 68 of the paper book notes. Kindly compare class 12 with Form 3.
Yes.
Right, it is identical. This form is part of the rule. Therefore, parties are bound by the contract of the lease cum sale agreement. One judgment of
how would the Form 3 will help you?
Please. Form 3 would help only for this reason. The obligation of execution of sale deed immediately after 10 years would be only if there is no breach on the part of the petitioner. Now, the non-construction of the building within 5 years or any extended period within 10 years, that is a breach. Therefore, if there is a breach, then the obligation of execution of sale deed immediately after 10 years, they can't enforce it.
No, then if very well, they can't enforce, then how would you say that, what would be the effect of 19.7 then? 19.7.2.
19.7.2, after completion of 10 years, there is no construction. I have not exercised my power of cancellation. Then the petitioner will continue as a lessee so long as she has not constructed the building and asked for sale deed. Even after 10 years, if the petitioner construct the building and ask for sale deed, we will execute the sale deed.
No, otherwise the status quo would continue.
And merely because I forfeited my right of cancellation, that would not entitle the petitioner to seek for execution of sale deed without construction is my respectful submission.
Let's understand very well.
Please.
That's the submission.
Please.
Then where is the power to impose penalty for execution? How do you get that power?
We have exercised that power only under the amended rules and the consequential instructions by the government. I would put it in this way. If there is no amendment, there is no instructions by the government. If there was a request by the petitioner, we would not have considered for execution of sale deed without any construction. That's what I have narrated in paragraph number 19 of the statement of objections. I have suggested to the learned single judge, all right, you recall that order of grant of execution of sale deed. Let the petitioner construct. We will execute the sale deed without imposition of any penalty. Under the very same impugned endorsement, we said you pay the money, take the sale deed. The petitioner took the sale deed, paid the money. Then after 1 year, my lord, approached this honorable court for a refund of the amount. No, that cannot be, my lord, such a conduct cannot be appreciated. Not if the petitioner had challenged the, my lord, if immediately after 10 years, if we have not voluntarily executed the sale deed in terms of Rule 1972, the petitioner did not approach this honorable court nor the authority saying that you have forfeited your right of cancellation. The lease period of 10 years is over. Therefore, execute me the sale deed. The allotee did not come forward with such a request. And even when we issued the impugned endorsement, they did not challenge it. Right? They accepted this.
So they did not approach you saying that now you have to under 1719 Rule 7.2, you execute a sale deed because that's an obligation on your part.
Yes, they did not enforce that right, which now they are trying to demonstrate.
So how did they approach you?
Right, they approached the authority with a request for sale deed. Simple request. We issued them the endorsement saying that you have to pay 6,60,000.
Which they paid.
They pay. Of course, they said it is under protest. They took the sale deed. After 1 year, this writ petition is filed. It was open for them to challenge it at then and there itself, instead of paying it and taking the sale deed. Not one judgment of the.
But tell us one thing. Otherwise, in that amendment to 23, you could have brought in 99 lease after 91 also. You could have.
Yes.
So you did not bring
the
it.
government has framed that rules. It could have been done. Directly on the point, there is one judgment of the learned single judgment. I could not place it on record.
Why consciously the rule says 2001 to 2005?
That I have answered day before yesterday. For this reason, between 2001 and 2005, there was no concept of lease deed and then sale deed. Immediately on the allotment, the authority would used to execute the sale deed itself directly. Then this honorable court, in one of the matter pertaining to BDA, has observed that the concept of execution of sale deed immediately after allotment would encourage the people to sell the sites allotted by the authority for a higher price, and nobody will construct the houses. Then the government took note of the observation made by this honorable court and amended the rule, which was prevailing prior to 2001. Between 2001 and 2005, there is no concept of lease. There used to be absolute sale deed immediately. Those are the persons who did not utilize the opportunity of obtaining the sale deed immediately after allotment to provide an opportunity when this amendment was brought in. Insofar as allottees prior to 2001, from 1991 to 2001, the position of lease cum sale agreement was prevailing. Those allottees who did not take the sale deeds between the allottees of sites from 1991 to 2001, who have not received the sale deed, even up to 2013, that they made a request to the authority saying that the benefit of execution of sale deed without construction and with a penalty may be extended to us also. Therefore, we wrote to the government. Government said, you apply the same formula in respect of the allottees of sites from 91 to 2001. That is how, this subsequent instructions by the government has been received by the authority. Kindly see this judgment on the point. This is a case of allotment of site on 23/2000. This is a case of allotment of site on 23/2000 minutes prior to 2001 amendment. Here also, my lord, the petitioner sought for a sale deed. Sale deed was, and penalty was imposed. He paid the sale penalty, obtained the sale deed and asked for refund, my lord, by filing a writ petition. My lord, kindly see para 7, page 6 of the judgment. Married. It is not in dispute that the petitioner was allotted the site on 23/2000, and it is the petitioner who made a representation on 21/11/2019 for execution of sale deed without having put up construction on the property, which was not in accordance with or in compliance with the terms of allotment contained in the lease cum sale agreement executed on 6/7/2000. The petitioner wanting to obtain a sale deed in the year 2019 was aware of the amendment which has been passed to Rule 20 of KUDA Rules 1991. The said rule reads as hereunder. The same rule, my lord, which has been extracted. Kindly come to para 8. A perusal of subclass 3 to the said rule 20, proviso 3 would indicate that in the event of allottee wishing to obtain a sale deed without complying the requirements of the lease cum sale agreement, 25% penalty would have to be levied. The said proviso 3 would only apply if a allottee were to seek for execution of the sale deed in his favor without complying the requirement of lease cum sale agreement. In the event of the conditions of lease cum sale agreement having been complied with, the question of levy of any penalty would not arise. In the present case, the petitioner not having complied with the requirements of construction as insisted upon a sale deed being executed in his favor, and on his request, a demand having been raised. The said demand has been fulfilled by making payment of the amount by the petitioner and sale deed obtained. Thus, the benefit having been obtained by the petitioner pursuant to the request made. I am of the considered opinion that the benefit having been obtained, the question of petitioner challenging the notice and of seeking for refund of the money would not arise. Hence, the petition is dismissed.
This is an allotment before 2001.
2001. Unlike the petitioner's case, here also, my lord, the allotment is prior to 2001.
It's more on facts when a demand made.
Yes.
That you have the petitioner herein has paid the demand.
But here also petitioner has paid the demand, got the sale deed. But where the main object will have to be seen, my lord, is, and once again, I would reiterate my submission that the object of the enactment and the rules, my lord, will have to be taken into consideration.
But here the payment is made under the annexure M, my lord. The payment is made under the cover of a letter at annexure M 107, where, my lord, she says, I'm making this payment under protest. So therefore, the rationale that is found in para 9 does not apply here.
You said para N,
Page
annexure N?
107, my lord.
107.
While the aforesaid letter under reference, you have placed a demand for payment of sum of rupees 6,60,000 being 25% of market value of land. While I feel the said penalty is payable only in respect of transfer of allotment, I am constrained to make the payment of the sum demanded under protest. Kindly receive the said amount of so-and-so as declared so-and-so and obliged. Having complied with your demand as aforesaid, I request you to execute the same. So she makes it clear that she's making the payment under protest.
Only one request, can you file your note of submissions?
Yes.
By tomorrow morning?
Yes.
Both of you?
I shall.
Just file it.
Yes.
And refer to those orders and judgment you have relied upon, so that we'll have it on record. Give it to the court officer.
Will do.
Just say this, we have heard the learned counsel for the parties. We reserve the appeal for order. We reserve the appeal for judgment. Counsel for the parties shall file their note of submissions along with the, by giving reference to the judgments, orders they have relied upon during their oral submission today, by tomorrow. Thank you.
Please. Only one submission, my lord, the authority of the government to issue such instructions, it is contained in the act. The government in the aid of implementation of the rule can direct the authorities to perform their function in such a
Say in
way.
your submission.
Yes, please, I shall. Public.
Let's take this. For them to execute the lease and construct it. Yes.
Be taken up next week. This involves challenge to betterment charges levied at the time of application for khata to be issued.
What are these
For the
21.1, 20? What are these 21.1, 21.2 and 21.3?
My lord,
They're connected appeals.
they are the levy of betterment charges is challenged, my lords, in this. When my petition was pending, the other matters were disposed of against which these appeals were preferred. So when my writ petition was disposed of and I preferred a writ appeal, it has got tagged along with those appeals.
But these writ appeals, in these writ appeals, that is 21, 2, 3, 2 and 3, based on your judgment, they were also dismissed.
Their writ petition, the levy of betterment charges was upheld in those writ petitions, my lord. The condition that it cannot be insisted upon prior to issuance of khata was cancelled. Against that, they were already in writ appeal. Subsequently, when a demand was made against me, I filed a writ petition. Based on the order passed in that case, this court held that a coordinate bench has already decided, therefore, in accordance with that, matter can be disposed. Aggrieved by that, I am before this honorable court.
That is 56465.
No, my lords, my writ petition is 729. The earlier writ petition is 56.
The earlier is that.
Yes, my lords.
That is.
The earlier is 564.
That is writ appeal 1580.
1581 of 2017.
Because the learned judge has followed that mandate in that only,
Yes.
564.
There are two aspects in that, my lords. One was that the betterment charges levy, the rate was upheld. But the stage at which it can be recovered was quashed earlier. That was not clarified. In my case, at the stage when I have applied for khata, the demand has been made. And this is made under a circular which was in 2012, which has subsequently been quashed. And in 2021, when I finished construction and applied for khata, on the same basis, further demand was made. So my claim is that since that circular is quashed, unless a fresh notice is issued to me asking me to pay, this demand cannot be sustained. Whereas in the other cases, that quashing itself is challenged. The refusal to quash is challenged of the subsequent circular.
We'll have it, who appears in the connected appeals? At the request of counsel appearing for the appellant now.
In 729.
Writ appeal 729 of 2022. You appear for the respondents?
No, I appear in the first matter only, my lord. In the other three matters, Mr. Puttegoda appears. Now he is unwell. The alternative arrangement has been.
Additionally, we have been informed by Mr. B.V. Murlidhar that Mr. Puttegowda, Mr. K.N. Puttegowda, who appeared.
My lords, in writ appeal 1581/2017.
You appear for the?
Appellant, my lords.
Mr. Puttegowda, who appears for the respondent in WA 6869/2017 is also unwell. He is unwell.
Please.
Re-notify the appeals on. Counsel for the parties to file their written submissions along with the judgments, if any, they wish to rely upon 1 week before the next date of hearing. What is the date, ma'am? Ma'am, just show us this 21.1, 2 and 3.
For many days, once he is not coming.
Please, my lord.
Show me the.
I go to
other
This as
Berkeley.
well, man.
point.
Alternative arrangement has to be made by the BBMP, my lord. I will inform.
I think he is not coming to the.
Yes, he has stopped. He can't speak, my lord. Speech is affected. Alternative arrangement is to be made. In many cases, alternative arrangements have been made. In this case, my lord,
It was not.
I will inform
For-
the.
For BBMP.
BBMP.
And you are also appearing for BBMP.
Yes, yes, in the first matter.
Take care.
Yes, I will inform them.
Now these appeals, 21.1, 21.2 and 21.3, those arises from 26th August 2016 order. It appears because these are 2017 appeals.
Yes, my lord. Yes, my lord. 5465, that is dated 26th August 2016.
Where are these respondents? B.U. Mallikarjuna is here. 2247. So much is the date,
This letters.
Purushottam Reddy. That's right. What about this 321.3? 21.3.
The first one.
First one mentioned. Where is the third one?
5672.
No, 6869. This 6869 was also part of that batch?
Yes, yes, my lord.
Huh?
Yes.
WP number 56465.
First one.
6869 doesn't seem to specifically mention. Because I have a copy of the order.
Oh, yeah, it's part, we have seen that. Okay.
I appear for appellant, my lords, in writ appeal 1581.
Yeah, we'll just mark your attendance also. Just mark her attendance.
Kindly grant one short accommodation. my
We have
lords.
given you date. Just give the date to her, man.
For the appellant, your lordship, there is delay of 88 days in filing the appeal, your lordship. That will be.
Pardon?
Don't. There's a delay of 88 days in filing the appeal, Your Lordship, that may be confirmed.
That the reference is made to the civil court under section 31 LA Act. Since there is a dispute between the appellant and other respondents, 3 to 4, my lord, therefore, other single dismiss the writ petition. You have to work out before the reference court. Title dispute between the parties, my lord. The lordship can see in the first instance, they filed a writ petition at page 175, annexure T. Seeking identical relief. This are court dismissed and directed them to work out before the reference court. What they say, my lord, we are the absolute owner, therefore reference is bad. That's what they're saying in the writ petition. That cannot be adjudicated in jurisdiction.
So there are disputes also in between persons.
Yeah, between the appellant and other rival claimant. Therefore, he passed award, sent a reference to the civil court for adjudication, determination of adjudication of the rival claims under section 1331, which is registered LSC 13 of 2014. Therefore, Leonard Singer dismissed the writ petition, saying that you work out before the reference court. It's a disputed fact that cannot be adjudicated in jurisdiction.
No, is it between the appellant and the?
Other respondents 3 to 4, rival claimants.
Or is there any dispute amongst some other persons also?
Yes, ma'am. They are the rival parties are respondent 3 and 4.
See, you see, no, not only 3 and 4. Is there any dispute with regard to others also? Like, just see para 2 of the order. As regard the claim of certain other persons who claim interest, certain other persons.
Yes, my lord. That's the one
At
Chandra
page
also there,
16,
my lord.
at page 16. So not only him,
Correct.
but certain other persons also.
Yes, my lord. Because
What
in
do you
this
say,
world-
ma'am?
Lordship, there's actually, Your Lordship, there's a matter pertaining survey number 96, 98, 100 and 101. There are also one more survey number 99, Your Lordship, wherein the coordinate bench has passed an order that the fourth respondent, they don't have rights over the property, Your Lordship. That is the decision. I may be permitted to,
But
in that,
these plea, don't you think need to be agitated before the court concern?
please, Your Lordship, but they have not.
I very well will see it.
Your Lordship, that is pending since.
This dispute, the dispute between
A prayer.
between 3, 4.
Lordship in the.
The property was belonging to you,
Please, Your Lordship, it was belong to me.
right? And you yourself wanted to have some,
Project, please, Your Lordship.
what is that?
Project, for some project,
Some
please.
project. Then why did you approach them?
Your Lordship, we approached KADB, Your Lordship, as
Why?
per the,
Why?
because Your Lordship, at annexure J, Your Lordship, first we approached Karnataka Udyoga Mitra. They told to approach KADB, Your Lordship. It is annexure J and annexure K. Even the endorsement is
His
also
own
there.
Property, he wants to do it, then you have to.
And even have produced.
Those lands were acquired
Why?
and acquired by the state under the Provincial KD Act. Now, their project was approved, they want allotment, that is not dispute, my lord. What they say is, my lord, reference made to the civil courts of a determination, comp itself is bad. They're seeking declaration of dishonor court, declared that it null and void. That is the prayer in the writ petition.
You acquired irrespective of their project,
Several lands were acquired, including their lands. That was allowed.
not at their instance.
It's a
No,
government, government are acquired, my lord. General thousands of acres are acquired by the government. One of them, they are the applicant for allotment of land. Project were approved by the competent authority.
They may be entitled for allotment of very land, but so far a payment of compensation is concerned. There is dispute, therefore award is passed and sent to reference court as per law only. They are seeking writ in the air to declare that a reference made to civil court itself is null and void. This Leonard Singh has said, even the first and the further writ petition, this on court has dismissed the writ petition page 175. Pay Alexa T. Malad, Last Justice Bomada Sadar. Again, they filed the same writ petition. They are also to dismiss and directed to one court before reference court. Page 177, Malad. Annexure T. The very same petitioner. That's certain finality. There is no challenge to that order. Para 4, Malad. Para 4. Having heard learned counsel for the parties in the above background, and as already noticed, the land being acquired benefit of respondent is not in dispute. The only issue is with regard to the apportionment entry compensation payable to that regard. There is communication dated soon, annexure petition will disclose that since respondent has also made a claim respect of the property in which for additional claims ownership right, as far as the terms of provisions contained in section 30 of the Act, are deferred amounts also. If there be this position, right of the respect of property concerned and entire compensation is established before reference court and apportionment order are to be obtained. Hence, and as far already taken step to depart the amount before reference court, a direction as sought in instant petition would not arise since the very covenant refers to data sum. Now, this has been attained finality. Again, the
Lordship,
second petition.
I may be permitted to make one submission, Your Lordship. As I mentioned earlier, Your Lordship, regarding the decision of the coordinate bench in survey number 99, when it is clearly held that that is also regarding the respondent, they all belong to the same family. They are claiming their right from one Narayanappa, Your Lordship. In that case, in the writ petition, that is clearly held that the respondent number 4, they don't have any rights over the property. It is clearly held in this decision, Your Lordship.
If
Therefore,
it is the case, they have to place before reference court, they could have seek it for disposal.
You go there and produce.
They can place it before reference court. It's a binding on the reference court.
See, on that count, because
they can seek for.
you have the benefit of one writ.
Order of dissolved court.
Please, Your Lordship.
Can it be a ground to say that the reference itself is void?
Please, Your
It
Lordship.
may be, to their benefit, it's best,
Produce that.
it is the best piece of evidence, Malad.
Reference court and get the order.
It is the best piece of evidence in their favor.
Please, Your Lordship, the LAC is pending since 2013.
Correct.
Please, some direction may be given to
Yes, that-
dispose of the
Objection.
speedy disposal, at least that is also.
See, better is you go there and you work it out.
Yes.
Please, Your Lordship.
Better would be go to that reference court and you work it out. And the remedy is only that.
Please, Your Lordship. But
Okay.
I'm only
So-
seeking that direction for speedy disposal, Your Lordship. This
See,
pending
we don't
since
know what are the stage, we don't know what is the, who are the parties. What the learned judge has said is remedy for you to is to approach the reference court.
Please, Your
And we don't see anything wrong in that saying. Okay, if we can record your submission that in view of the order of the learned judge, you will approach the reference court.
Please, Your Lordship.
We'll dispose it out.
One direction may be given, Your Lordship, regarding the speedy disposal, Your Lordship. It's still that one observation may be made. Your
You will work it out, ma'am, not like this.
Please, Your Lordship.
Okay, you want to withdraw this?
I will,
In view of the order of the learned single judge.
please, Your Lordship. Before that, Your
Let her
Lordship.
go. The learned
that, Your
counsel
Lordship-
for the appellant.
Your Lordship, I may be produce this, permitted to produce the wakalat, Your Lordship, fresh wakalat. My senior Hari Krishna Holla is no more. So after that, we are filing fresh wakalat from our own office.
Just take it.
We taken on record, Your Lordship.
And what about the delay? How much is the delay?
88 days. That is after
On that delay. What is the IA number?
I have 1/22, Malad.
one of
22.
Which one?
I have
Number one.
1/22.
1/22. This is an application filed by the appellant seeking condonation of 88 days delay in filing the above appeal for the reasons stated in the application. Notice was not issued to 3 and 4 now.
no, Your Lordship, not.
Even before the writ court also.
There, Your Lordship, some
No,
LRs,
one.
that
No,
person
no.
is dead and LRs are also coming on the records, Your Lordship.
There
It is issued. LR,
Even
LR
the
application
learned
was
counsel
filed and
appearing for the respondent number 1 and 2 has no objection if the delay is condoned for the reasons stated in the affidavit
They were served before the single judge.
and the prayer made in the application. The delay of 88 days is condone, the application is disposed of. The delay of 88 days in filing the appeal is condoned. The application is disposed of. Now say writ appeal. Writ appeal, the learned counsel for the appellant states that in view of the order of the learned single judge, the appellant shall approach the
Writ petition number
concerned-
27602.
the concerned civil court, the court of senior civil judge
Devanhalli.
and JMFC at Devangre.
Devanahalli.
Devanhalli.
Devangre.
Devanhalli.
That is by mistake, my lord. Actually, it's Davanagere is a mistake, my lord. It's
Dev-
Devanhalli.
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 Yes.
Devanhalli.
LAC number 13 of 14.
In LAC number 13 of
2014.
14.
Noting the said submission, she wishes to withdraw in view of the order of the learned. In view of the said submission, the petition is dismissed as withdrawn.
Yes.
Thank you.
There are other applications, my lord, that may not serve.
The other applications have become infructuous.
Disposed.
There is only one additional documents.
That they can urge before the reference court.
Yes.
Not subject for the appellant.
Yes, sir.
The
Respondent
petitioner,
number
I am making a submission. The petitioner not basically they filed a writ petition seeking to modifying the conditions imposed in a tender document. They wanted to issue a fresh tender document by modifying the conditions. Not Annexure A, not it reflects not this tender was issued during the month of 17/6/2022 and duration was only 12 months.
My lord, it was
Only 1 month.
1 year, my lord.
1 year.
That expired.
It is infructuous, my lord. So
What remains in this?
nothing would remain.
You want to withdraw this?
Lordship may record my submission.
Learned
Submission
counsel-
states infructuous.
Learned
The-
counsel for the,
My lord,
Yes.
just one submission. The work is substantially done. It's in the last stages. Substantially done. It was awarded in the month of April. So there was some of last
April of
last year.
last year.
It's almost done, just a little bit remaining. That's the only substantially done that can be recorded
So the work has been allotted.
to someone else.
The tender, Mallards, it was in the year 2022, but according to him, it is awarded in the year
We
2023.
can record this, that you challenge the conditions in the tender document.
Yes.
According to you, the work has been allotted.
Please,
In view of this, she has become infructuous.
please.
See, the gentleman who has been awarded, he is not even a party here.
Party. And they should have challenged the
You
work
should
award.
have challenged that award,
Work award.
but on the ground would have been same.
Yes.
Ground would have been same,
Ground would
unless
have
and
been
until there is some other ground.
Please. But then the fact that they've completed the work would weigh in the favor of the awardee almost substantially.
We'll say this then. We will say the challenge in this petition, in this appeal is to an order dated. Order dated
9/9/2022.
9/9/2022. Whereby the learner single judge has dismissed the petition filed by the petitioner appellant herein. The learner counsel for the appellant fairly states that pursuant to the notice inviting tender, the work has been awarded to a third party. That's right?
Please,
To a third party. Full stop. This fact is also acknowledged by the counsel appearing for the
respond number 2 and 3.
respondent number 2 and 3. He also, this counsel also states that the third party is almost on the verge of completing the work. Full stop. The learner counsel for the appellant states that he does not wish to pursue the present appeal. The appeal is dismissed, be dismissed as withdrawn. The appeal is dismissed as withdrawn. Any pending applications are disposed of as infructuous.
Grateful.
My lords, I appear for the appellant.
Yes.
But the short question, my lord, that arises for consideration is, but the learners, there is a delay of 3 days filing in appeal, my lord.
But what is the challenge here?
But but what has happened, the society may not have passed a unanimous resolution by the general body, but for amending the bylaw, but in conformity with the Societies Act 15 to 17. Then
Yes.
they increase the board of director in conformity with the Cooperative Societies Act.
But Mr. Shetty, your prayer has been accepted by the learner single judge.
Yes, but partly it was allowed.
What was not given then?
Then the annex, the relief B and C. Lord, what?
Just come to page 18 and 19, your prayers in the writ petition.
18 and yes. Yes. But the learned judge may not, they granted this was may not, what was the 2 and 3 was, I am aggrieved by non-consideration of the prayer 2. If your lordship permit me, I'll read it, will not the subject.
Let's see the directions also of the learned judge.
Yes, but the learned judge will not the set aside the.
He has granted 3A.
Please, my lord, sir. Yeah, please, my lord.
He has said so also on holding elections.
Yes.
That is
the holding an election in accordance with the existing bylaw without reference to the general body resolution, as well as the second respondent who have as an administrator has amended the bylaw without that was struck down by the learned single judge.
So what he said is 3A, 28 to 22 and 25 for 22 is quashed.
Yes, my lord.
And 3 to take necessary action for holding elections without reference to those orders.
Please, my lord.
3 and 3A are granted.
3 and 3A are granted.
Yes. But I am not requesting your lordship to hold an election. But election is already over, that everything. But only our grievances. But we made the application for the application, but amending the bylaw by incorporating the earlier, as per the earlier bylaw, the maximum director will be 15. The after amendment of 2013, that has been, there will be the provision for 17 directors. The general body passed a resolution for 17 directors. That was forwarded to the second respondent as per Annexure B at page 56, your lordship, in the paperwork.
That's what it says. To declare that bylaw number 23 presents after general body of so and so is deemed approval as per section.
Section B is 22 to 22. 25. As well as Annexure B is 28. Now tell us one thing.
Please,
if you
Lord.
see your prayers,
yes,
are you aggrieved by this direction of the learned judge at page 23, page 7?
But I am not aggrieved by the order of the learned single judge. My grievance is non-consideration. But I fully agree with the learned single judge order, except non-consideration of the prayer 2 and 3 has not been considered, but that is my grievance. But except
Now,
let's
let's see 3. Let's see 3.
Yes.
Your prayer 3.
Please, your lordship, sir.
Issue writ certiorari to quash annexure D dated 13/10/21 bearing this, passed by second respondent and declare that bylaw number 23 annexure B passed by the general body on third respondent is deemed approval as per section 12A. So you are saying 28/1/2021 must be treated as deemed approved.
In conformity with the law. That is the mandate of the legislature.
That's okay. So you say that it should be treated as deemed approved.
Deemed approved because my lord, I have filed an application on 28/1/21 as per annexure B. That was rejected on 23, on 13/10/2021. My lord, the proviso, my lord, I have stated that the section 12(2) proviso was very clear. If it is not rejected within a 90 days, it is a deemed approval. My lord, it is a law contemplates it.
But he says without reference to 28/1/21, the elections must be held.
Yes, that has been held, my lord. That has been held. That now the election has been held. I have no grievance.
So then
I am
tell
not
us one
requesting your
thing.
lordship to set aside the election. I am not challenging any order of the learned single judge. I only see non-consideration of this deemed because
So what you are saying is the amended bylaws which you have sent for approval, they have not been accepted.
accepted or rejected within a period of 3 months.
So
Therefore,
deemed to
my
have
lord,
been approved.
beg your lordships.
Deemed to have been approved.
Yes, my lord. Yes, that is my submission before your lordship, my lord. It should be declared that by virtue of the mandate of the provisions of the act, legislatures act made in the by that has to be done. That is the
What do you say? Though elections have been held without reference to 28/1/21.
yes, my lord. Yes, yes.
But you are seeking now in the absence of any decision within 90 days deemed to have been approved.
Yes, yes. My lord, I am not going to challenge the election. I only
You are not challenging election.
No, I am not challenging election. I
but
only
so-
said that there is a
Yes.
deemed approval of the bylaw that has to be done. That if your lordship accept my contention, it will be only prospective from that date. I am not asking to the retrospective at all.
But you are
For
saying at
election,
least
my lord, I don't
future,
want to seek nullify the election already taken place. They are all functioning.
you are right. At least what you are saying is the future would be governed by these bylaws, amended
Yes,
bylaws.
that has been in conformity with the law made by the legislature because they enacted it by virtue of the 2013. That has been, we have implemented it.
Without even proposed. No election rules. Future. But this, for future, what? But there is a prayer too. It's prayer.
will be no cancel. Yes, what do you say?
The petition has been redressed. Secondly, this is respondent for 3 union did not amend the bylaws within time. Who want to amend the bylaws came to be.
Will issue notice. The submission of learned counsel for the appellant is with the learned single judge. While disposing of the writ petition, had not considered the prayer at 3, small Roman 3, wherein the appellant herein has sought a declaration that bylaw number 23 as per Annexure B dated 28/1/2021 passed by the general body of the third respondent is deemed approved as per section 12 bracket 2-A capital A of the Karnataka Cooperative Society Act and as per amended section 28 capital A bracket 2 bracket small Roman 1 bracket D of the Karnataka Cooperative Society Act. First, issue notice, so and so accept notice for respondent number 1, 2, 1 and 2, 1, 2, 4, 5 also, no, 5 also, 5 and 6. You don't require returning officer. Now the elections are over.
Yes, Bernard, I think it's only between the.
1, I'll tell you. It should be 1, 2, 3 also? No. 1, 3, 4, 5. Notice is accepted. No notice is required to be sent to respondent number 6, as it is the case of the counsel for the appellant that he is not challenging the elections as were directed by the learned single judge. That's right, Mr. Shetty?
Please, Bernard, your lordship is perfectly.
Let notice
That's in
be
order.
issued to respondent number 3, returnable on.
Much obliged.
For the respondent.
If the appellant's counsel is the matter wherein survey notice was challenged in the writ petition. The learned single judge quashed the same on the ground that there is a civil suit pending between the parties. I had pointed out the fixation of boundary is one of the subject exclusively within the revenue jurisdiction. And further, pendency of the suit will not in any way prevent the authority from doing it, or it cannot prevent me from approaching the authority to get the boundaries fixed. Under section 61H, in effect, learned single judge has exercised writ of prohibition almost.
Your lordship, the decision held by the learned single judge saying that when the matter is seized before the civil court, the revenue authorities cannot act without the necessary application before the civil court, your lordship. The learned senior counsel during the last occasion mentioned about section 61, your lordship, section 61 of the Land Revenue Act. Your lordship may kindly see section 61 of the Land Revenue. Lord, it says, save as otherwise provided in this act or any other law for time being in force, a revenue court shall have jurisdiction to determine, decide, or dispose of any matter which it is by or under this act empowered to determine, decide, or dispose of any, and no civil court shall exercise jurisdiction as to any such matters. Lord, the clause 2, subject to the exceptions hereafter specified, no civil court shall exercise jurisdiction as to any of the following matters. There are set of matters which has been mentioned, Your Lordship, A, B, C, and Your Lordship may kindly see section 62. Lord, it says nothing in section 61 shall be held to prevent the civil courts from entertaining any of the following suits, namely, kindly see clause B, Your Lordship. Suit between private parties for the purpose of establishing any private rights, although it may affect by any entry in any land record. The particular suit which we are dealing with, Your Lordship, is between the two private parties. When such suit is filed between two private parties and it is seized before the civil court, the revenue authorities cannot entertain, Your Lordship, without making a necessary application before the civil court. And the suit for possession and damages between those private parties is not barred under section 61, Your Lordship. When the matter is barred before section 62 clause B, it is not barred under section 61.
I'm not in any way coming in the way of my, that civil suit being heard or this thing.
What is the suit for?
Suit for
Possession and permanent injunction.
possession and permanent injunction.
Only injunction. Possession.
Possession and permanent. Your Lordship may kindly peruse section 140 subsection 2. If any dispute arises concerning the boundary of a holding which has not been surveyed, or if at any time after the completion of survey, a dispute arises concerning the boundary of a survey number, a subdivision of a survey number, or holding, Tahsildar shall decide the dispute having due regard to the land records if they afford satisfactory evidence of boundary previously fixed, and if not, after such inquiry as he considers necessary.
140?
140 subsection 2. So fixation of boundary is specifically entrusted under revenue jurisdiction to the Tahsildar. (61H) says section 61H says the boundary dispute and fixation of boundaries is not one of the matter wherein civil court can do (61H) claims regarding boundaries fixed under this act or under any other law for the time being in force, or to set aside any order passed by competent officer under such law with regard to boundary marks or survey marks. This is one category which is prohibited, or rather jurisdiction is expressly barred. 61 subsection 2. The learned single judge takes the view, there is a suit pending, therefore this should not be done. I would respectfully submit that.
The injunction, it is only injunction suit.
Possession and.
Where is your prayer in the application?
In the
Where is your prayer before the revenue authorities?
application. Its application is not produced, but annexure D would give the gist of it. Malal, do you lordship may kindly annexure D, page 53, it's in Kannada. Next translation is at 54.
What is Hadubastu?
Haddabastu is fixation of boundaries. Haddu is boundary.
But now you are seeking fixation of boundaries there.
Yes.
If that be so,
In the suit, what has happened is, when my injunction application was being considered, it was said
what is the injunction you were seeking?
I am seeking injunction, of course, I am seeking with regard to my extent. I have claimed that my extent is 1 acre, 12 guntas, whereas a portion of it has been encroached and I had sought for injunction. I am not contending that suit is not maintainable or anything. All that I am saying is, if I can get the boundaries fixed, that would become the material evidence for me to put forward before the civil court. Learned single judge now says, you can make the application in the civil court. That would, of course, there again, it may not be a court commissioner. There again, civil court may have to direct that under 140 subsection 2, it's only Tahsildar who can do that. Of course, it may direct, it may not direct is another thing, but at notice stage.
See, what is that, annexure A, the order passed by the court in the OS 220 of 16. It says that it is no more an agricultural land. It has been amalgamated into the panchayat.
That aspect, my lord, is covered
then
that is covered by the division bench judgment which I had submitted on the last occasion. Court has taken the view, so long as it pertains to the land with reference to a survey number, it is under the Land Revenue Act, even if it is within the.
it has been taken over by.
Yes.
panchayat.
That the division bench judgment which I had given on the last occasion. Para 8. Shall I read para 8? typed page 10, last about 4 lines.
See, can the impugned order restricts him to avail a remedy under the revenue law if it is available?
Your lordship may kindly see the annexure H he has mentioned, your lordship. It mainly concerns to matters which are dealt under section 61. The subject to the expression herein after specified, no civil court shall exercise jurisdiction to any of the following matters, namely claim against the government relating to any property appertaining to any office or any other. This is not the claim against the government, your lordship. This is claim
Right,
against
but
two
you
property,
see,
two private parties, your lordship. There is a judgment of coordinate bench which I don't have in my hand, your lordship.
you see, 62B suits between private party for the purpose of establishing any private right. Although it may be affected by any entry in any land record. Suppose even there is any land record which is being disputed by one party and contested by you know, the other against the other party. Such a stipulation, such a suit would lie before the civil court. This is what being clarified here.
Yes, my lord.
But the thing is, when it comes to 142, any dispute arises concerning boundary of a holding which has not been surveyed, or if at any time after completion of a survey, a dispute arises concerning the boundary of a survey number, a subdivision. But tell us one thing, what is your dispute before the revenue authority?
According to my assertion in the suit, my lord, my survey number measures 33 guntas. He has encroached upon a portion of it and has.
What
laid
is
the
your survey
foundation.
number? What is your survey number?
193.
What are you, and what has he, okay. So. So 193 is your survey number. According to him, he has encroached.
Yes, and he had laid the foundation at the stage of injunction. It was only foundation, but injunction was not granted, and thereafter it appears there is an amendment made seeking possession. In rejecting the injunction, one of the reasonings was identification of your extent and boundary was one of the reasons, which was, of course, not conclusively, but that is one of the reasons given by the civil court saying a specific boundary mark or anything is not available to be shown. Even without a suit or with a suit, the boundary fixation will have to be done by the revenue authorities. Therefore, my filing of the suit in any way will not make a difference.
He wants to know where they're voting.
See, how can the learned judge restrain a party to approach the revenue court which only has the exclusive jurisdiction?
Lord, it has the exclusive jurisdiction with regards to the suit which has been mentioned in section 61, your lordship, not with pertaining to section 62.
Very well, 62, very well.
61 specifically,
His grievance is 61.
but the suit is between the two private parties, your lordship.
No, but when it comes to dispute,
The OS which they have challenged is between the two private parties, not against the government. Your lordship.
now see 61 2H.
Yes, my lordship.
Claims regarding boundaries fixed under this act or under any other law for the time being in force or to set aside any order passed by the competent officer under such law with regard to boundary marks or survey marks.
Yes, my lordship.
Okay. Now, the dispute is, he says his survey number is 193
193.
and the other party is trying to encroach
Yes,
193. Will that not mean that there is claims regarding the boundaries fixed under 61 2H or under any law for the timing in force?
Lord, the revenue court shall have jurisdiction to determine, decide or dispose any matter which it is by or under this act empowered to determine. Between the two private parties, they are not empowered to determine the suit, your lordship.
They would not, but learned judge accepts that the subject matter of that suit shall lie before the revenue authority only.
My lord, at that time, they would have sought for, they would have made a necessary application at that time itself, your lordship,
Where?
for fixation of bond before the civil court.
No, is it necessary?
After the order was,
They say we will not make, we will go to the revenue authority. How can that be, they be barred?
Lord,
Is a remedy? Before the remunerator, they say we will not go there. We will go to the revenue authority.
Lord, it would violate independence of judiciary, your lordship.
What is independence? What is violation of independence of judiciary? Tell us. So everything, judiciary must take everything upon itself.
Lord, in
Then-
case if the matter is seized, they have to file a necessary application. Because the,
See, in that suit, it is a suit for possession
Yes,
and
ma'am.
injunction. Injunction and possession. We are now, court is not concerned about the boundary between you and him.
it would
It
change
was
the
not- it
nature
is
of
not-
the property, your lord.
Not an issue. It is not an issue.
If they do so, it will change the nature of the property, your lordship.
See, we will tell you, by this order, the provision under the Revenue Act has become redundant. He is being precluded to go to the revenue authority.
Yes,
That's
ma'am.
right. Can the impugned order say so when the power lies
Can-
here?
Can you say, by filing an injunction suit, the land cannot be surveyed by the revenue authority without the order of the court? It is a mere injunction suit.
Yes, ma'am.
A person or the owner whose name appears in the records, he goes to the revenue authority, please measure my property. Can an injunction suit prevent that also?
This is also suit for possession, your lordship.
Maybe.
Based on the finding of the revenue authority, he will
You take up
proceed.
the contention, whatever the law permits.
I'll leave it up to your lordships to decide.
You appear for?
Your lordship, I may be kindly permitted to file one.
3.
Authority, your lordship.
Which is there, show us.
It was held by the three-judge bench, your lordship, of this honorable court.
Which page, which paragraph?
Your lordship may kindly see page 58. Para 43, your lordship.
Matter arose with reference to court fee valuation to be made for the purpose of court fee. Court took the view the lands which are situated within the municipal limits will have to be valued as non-agricultural property itself for the purpose of court fee and valuation.
The Lordship may kindly see para 40.
And that has been referred to in the division bench judgment and has pointed out that will not be applicable.
Lordship, in that particular paragraph, page 58, Your Lordship, page 58. Last 6 paragraph. It was argued that, Your Lordship, the revenue officer was authorized to change mutation entry and record of rights only on the disputed facts. The undisputed facts, I'm sorry, Lord. The jurisdiction of revenue authority is totally barred when the dispute of title was claimed or made. The same view was confirmed by this honorable court in this particular judgment in page 105, Your Lordship.
See this, how is it going to help you? The jurisdiction of revenue authority was totally barred when the dispute of title was claimed or made as held by the whom.
Yes, my lords.
This is only on the title, not on the boundaries.
The similar kind of power they possess, Your Lordship.
That arose under section 129 to 136 in making entry in the record of rights.
Making the entry.
Entry in the
Not
record.
drawing the boundaries.
No, it's under 129 to 136 and the court has held in exercise of power under 129 to 136 mutation entry etc. If a declaration suit is there and if the title is declared, that entry will prevail. Actually 136 provides for that. Section 136. Kindly see 135, specific section is with regard to mutation and this thing. Under section 135, specifically it is authorized to file a suit. Section 135, proviso.
Where is your copy of the suit?
Presently, I don't have the copy. Kindly peruse section 135, madam, with regard to the other judgment. No suit shall lie against state government or any officer of the state government in respect of a claim to have an entry made in the recorder or register that is maintained under this chapter, or to have any such entry omitted or amended, provided that if any person is aggrieved as to any right of which he is in possession by an entry made in any record or register maintained under this chapter, he may institute a suit against any person denying or interested to deny his title to such right for a declaration of his right under chapter 6 of the specific relief act, and the entry in the record of register shall be amended in accordance with any such declaration. Chapter 6, this deals with 129 to 136 is regarding the entries in the revenue records for payment of the land revenue.
Here the dispute is not.
This is about the mutation.
Mr. Patil,
please.
The judgment he has relied upon is primarily where there is a title dispute.
Where there is a title dispute, and your lordship may kindly see chapter 11, my lord, in a minute, just for the purpose of this. It starts with section 127.
But this dispute which you have raised, is it related to title or boundary?
It is regarding the boundary. According to my my land measures 1 acre 29 guntas or some such thing, and there is an encroachment.
Yes.
Boundary, fixation of boundary
But you
stones
should
are
have
not
filed,
available.
you should have filed your suit now, so that we could have had a.
Of course, that's one thing, but
And also the application you have filed before the revenue authority.
that I have, my lord, I will get it translated.
Oh.
It's in Kannada. I will get that I found it is here.
What do you say in that?
In that, I have specifically said, as per the original records, my land measures so and so. That is supported by some earlier dispute in civil suit, etc., where the extent is referred. Now, therefore, please fix the boundary showing the extent, etc., of this survey number. My
Is the suit
learned judge,
for
the
possession?
judge could say the.
According to you, your entitlement is 1 acre 29 guntas, but the revenue entry show only 29 gunta.
In one of the entry, it is shown as 29 guntas. I am saying so and so has encroached. He is the owner of the neighboring property. I have gone to civil court.
No, that.
If my survey number boundary,
You have not gone to see, he has gone to civil court.
no, I went to civil court and sought for injunction. My application for injunction was rejected. Thereafter, I sought for possession of that encroached portion. I claim if one boundary of 193 is fixed, then either it is encroached or it is not encroached. I will be able to.
Will it not be a title suit
Yes, ma'am.
It will not.
for the purpose of 1 acre?
I will say, I will go to this extent, my lord. My suit between me and the other person with regard to possession of encroachment or otherwise is a suit which is permissible. I am not contending that it is not
No,
so.
that you are, because you, in fact, you can't contend otherwise, you are the person.
Not only that, even if it were to be so, I don't say that for possession, I cannot go anywhere else. I will have to do it here. In that, the best of the evidence that I can produce is my land with this boundary. So and so has encroached a portion. Therefore,
You filed the copy of the plaint
I will,
of the suit you have filed and a translation of this.
please. I would respectfully submit, even otherwise, if the revenue authority has the jurisdiction to fix the boundary, haddabast, then it should not, my filing suit should not prevent.
You mean to say that if the boundary is now fixed.
Fixed.
You claim that it is 1 acre 29 gunta.
Yes.
But the revenue entry show only 29
No,
gunta.
preliminary entries show 1 acre 29. Preliminary records.
That itself is in dispute. That
It's a
itself is in
dispute.
dispute.
Yes.
So, unless that dispute is settled.
Even after fixing of the boundary, I will put it in.
To which extent?
I will,
1 acre 29
no,
gunta.
as regards 193, if survey number boundary is to be fixed, it should be fixed with reference to the resurvey settlement of 1927 and 1960. There are resurvey settlement
Whatever the subsequent
records. Records are there. On that basis, it would be fixed under section 140, subsection 2. In that, once the boundary is fixed, if I am to show that he has come within that boundary, I will get the relief.
No,
To decide the title itself, it's your lord.
It will also decide the title. It will also decide the title.
No, for that you need to show us the plaint.
I will.
Plaint may say that we don't have the plaint in our hands, number one. Number two, if the plaint claims declaration in respect of a title of 1 acre 29 guntas and the injunction.
Yes, madam.
Then, yes, That title to suit has to be decided. But you say that the injunction, you say that he has constructed some building, etc., and now he wants mandatory injunction. On that basis, that is, there is an encroachment, and therefore it has to be declared that it is illegally constructed. We don't have the plaint in our hands.
I will place the plaint, but I would submit, even with that suit, assuming all those things in that suit, I'm not saying suit is barred. The best of the evidence that can be produced before the civil court in that suit.
If that is so, if the dispute between you and him is in respect of whether it is 1 acre or 1 acre 29 guntas, would it not be?
No, he is not claiming survey number 193. I am not claiming survey number 192 and 194. He is the owner of those two adjacent property. I am not claiming anything in that. It is essentially a fixation of boundary. It may 29 guntas itself, or it may be 1 acre 29 guntas. Because
You file the plaint.
please,
Learner, senior counsel for the appellant shall file on record the copy of the plaint in the suit filed by.
And your written statement, you have filed the written statement?
Yes, my
You have
lords.
filed the written statement?
Yes, my lords, we have filed.
Copy of the plaint and the written statement filed in OS 220 of 2016. Plaint by the appellant and written statement of the, no. Plaint by the
Lordship, I'll-
plaint and written statement.
plaint filed by the appellant and the written statement filed by
If it
the
is filed, I'll produce.
filed by the respondent number 3. That's right? Respondent number 3.
In the appeal, he is respondent number 1.
Including a translated copy of the application filed by the appellant before the revenue authority.
He is respondent number 1 in the
One
appeal.
in the appeal, Your Lordship.
Respondent number
1 in the private party is respondent number 1 in the writ appeal.
Respondent number 1.
Hanif Saab,
No. You see that page 9, Hanif Saab. Okay, we will say that. We will say that.
That was the reputation.
Okay, we will say that. Okay, we were saying, okay, filed by the appellant and the respondent number 1. Plaint who has filed Hanif Saab.
no, plaint is by appellant. Kiran Kulkarni.
Plaint filed by the appellant, cut it off. Plaint filed by the appellant and the written statement filed by the respondent number
Yes.
1. Along with the translated copy of the application filed by the appellant before the revenue authority.
Yes.
How much time?
I call it next week.
When do you want?
I want it in the next week itself.
You'll be able to file translation?
Yes.
Let's start, let's say, next to next week. What is this?
That's all.
Yes.
I appear for appellant, please, madam. The other day.
Yes.
There is a ink page number 31 may kindly be perused, please, madam. Ink page number 31, please. The other day, I misread the prayer, please, madam.
Yes.
I am filing the synopsis, please.
No, this is only that notice, not 22(3).
No, 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 it is not notice, please, my lords. This is the order. This is the order requisitioning the premises under section 160.
That's right.
Yes.
But the quashing of the criminal proceedings is in 482.
So at least here, that is in IA, please, my lord. IA is filed for amendment of the prayer, please, my lord.
That has not been allowed.
That is not allowed. Here, so far as this is concerned, this prayer also has not been granted by the learned single judge. That is our.
It's all right. Because he says so, because 482 is the criminal proceedings under a challenge. You have sought the quashing of the proceedings. You have sought, Mr. Reddy, you have sought the quashing of the proceedings under 482 on different grounds.
No, that is IA, please, my lord. In IA, I wanted to amend my prayer. Forgetting about that, please, my lord. So far as this prayer is concerned, this prayer also has not been considered and quashed. This order also has not been quashed, though it is an honest order. So my grievance before this sample court, at least one is non-consideration of IA for amendment.
What is wrong in the learned judge to say
Please,
that 482 where you have sought the quashing of the proceedings, you go there.
no, that is not. So your lordship, kindly see the order. The order is that the order is at ink page number 17, please, madam. Page number, ink page number 19, please, Mila. Second paragraph. The petitioner Swami Vivekananda Rural Education Society, represented by its secretary, is before this the court calling in question the order passed by the third respondent on 22/3/2019 to hand over the premises of the petitioner for the conduct of elections to the Lok Sabha of the year 2019. The elections having been conducted and the orders having spent itself, nothing further survives for consideration in so far as quashing of the order is concerned. This is the there is a observation that is under challenge, please, my lord, precisely. Irrespective of whether the elections have been held, conducted, all those things, please, my lord. Whether the order is an honest order or not, that is to be declared by the sample court. That's what my prayer, please. Brief notes, synopsis.
Now, your argument is only in respect of requisitioning the premises which are.
Yes, yes, please, my lord.
So you are not pressing your other prayers.
There is no other prayer so far as the writ petition is concerned. That is the only prayer I have sought for. Other consequences, that is a other prayers are general prayer, please, my lord. So far as application filed by me for amendment is concerned, that has not been considered. In that, I wanted to incorporate.
See, that requisitioning, yes, it was done. And thereafter, the single judge has already passed an order that compensation has to be given for that.
I'm sorry, there were two writ petitions, please, my lord. Totally two writ petitions. Earlier writ petition, we have filed.
Not earlier writ
Alla
petition.
compensation ಬಗ್ಗೆ ಅಲ್ಲ.
Not earlier writ petition.
The prayer what I have read the other day is in the other writ petition. By confusion, I have read the other prayer, please, my lord.
Which is that prayer?
That is your list prayer. That is in respect of, I have sought for writ of mandamus in that, not to requisition the premises. That is at ink page number 45, please, my lord. It may be perused, please.
45.
Ink page number 45.
This is the earlier writ petition.
Earlier writ petition. So the day on which this order is passed in the earlier writ petition, please, my lord. Immediately they have passed this order.
What happened in this petition?
That petition is not to request this premises, please, my lord.
There is, what happened to this
So
petition?
direction has been given to the authorities
Saying.
to consider our representations. We have given
Now,
representations to the
what is the
DC.
ground you have taken?
So
We'll
earlier,
come back after lunch. We'll
obliged,
come back. After.
obliged.
Okay, we'll
Okay.
come back. Yes, Mr. Reddy.
So this, I was referring to the earlier writ petition, please, my lord. In the earlier writ petition, what we have sought for, because we smelt that they will be issuing another order for this parliament also, requisitioning our premises for this time also, because earlier for about 7 times we have our premises, please, my lord, without any protest. They have damaged extensively, as I already submitted that. On account of that, this time we wanted to prevent them actually. Therefore, we have approached this honorable court, please, my lord. And on 21st of March 2019, this honorable court was pleased to give a direction to the DC, please, my lord, by disposing of my writ petition to consider our representation, please, my lord. 22nd itself, they have issued the impugned order in the writ petition, please, my lord. Your lordship will come across with that order of this honorable court at page number 104, please, my lord. Para number 5, in view of the submissions made in the facts of the case, petition is disposed of with a direction to the Deputy Commissioner to decide the representation submitted by the petitioner by a speaking order within 3 days from the date of receipt of certified copy of this order passed today, please, madam. Before we obtain the certified copy and submit our further representation to the DC, on 22nd, the very next day itself, the impugned order came to be issued. Then immediately second writ petition has been filed, praying for quashing of the order, please. Annexure C. That is wherefore the petitioner humbly prays that this honorable court may be pleased to call for the records and issue a writ in the nature of certiorari or any other writ or order or direction, quashing the order, notice, letter dated 22/3/2019 passed by the respondent number 3 and grant costs of the proceeding, grant such other relief. That is the only prayer, please, my lord, that petition. And annexure C is at ink page number 48, please, my lord. This is issued purportedly under section 161A of the Representation of People's Act, and it is mentioned specifically that it is for the purpose of training and strong room and mustering and demustering center, not for polling station or storing of ballot boxes after the election as per the provisions of section 160, please, madam. And even in this annexure C, the compensation amount also has not been mentioned. What is the compensation they are offering? That also has not been mentioned, please, madam. And this is issued purportedly by respondent number 3, who is an election officer, who is not a government, please, madam.
Presentations of people like. 2021 amendment.
Just see RP Act.
It says it was amended in 2021.
Section 160.
Will take my. When they go to the implementation of it.
Just type it here. What happened is.
Below the
What is the pass number? Password? This has to be.
password, yeah. ಅದಕ್ಕೆ ಆಯ್ತು ಅದಕ್ಕೆಲ್ಲ ಇದಕ್ಕೆ
Just call him.
ಮೇಲ್
What's it say?
But this one was. This was one.
This is. Pictures.
Okay. Touch ಮಾಡ್ರಿ
Just touch it.
password ಬರುತ್ತೆ.
This is.
That is not there.
This is.
For the government.
I think. Remove model, password.
Yes, Mr. Reddy, please. Tell us.
There's nothing, please.
What is nothing? You have to argue.
Whatever I had to argue, I have already placed all the facts and as well as law before this server put, please.
What is the law?
The law is that it is an honest order, please, my lord, because it ought to have been.
1 minute, please. What are the contents of the FIR?
For a moment, my request, please, my lord. FIR, you just
No,
keep it.
we want to know. Okay, very well. So what you say is 2019 must be quashed.
That's all, please, my lord. That's all. This also, I have brought it to the note, your lordship may kindly say, what has been transpired. My lord.
See, it's very important. Yes, what do you say? Hmm?
One and four. In this, the petition also, we are represented 1 and 4.
You appear for 1 and
1 and 4.
4. Who appears for 2 and 3?
Central Government Standing Council appeared before the learned assembly.
Who appears now here?
Central Government Standing Council.
Who is the councilman? Hmm? Oh, this is a preliminary hearing. So we must ask for the applicants. Can we issue notice?
No, notice has been served, please, my lord. As directed by your lordship.
Who appears?
Your lordships are pleased to instruct me to serve the notice. I have served the notice on election commission, please. And filed the acknowledgement also.
Oh, stop.
Respond number 2. Two, sir, ಆಗಿದ್ರ ಬಗ್ಗೆ ಇಲ್ಲಿ ಇದನ್ನ ಹಾಕಿಲ್ವಲ್ಲ. Acknowledgement ಹಾಕಿದ್ದಾರೆ.
Here is the acknowledgement. I have sent this.
House list ಅಲ್ಲಿ respond number 2 served ಅಂತ ಹೇಳಿ ತೋರಿಸ್ಬೇಕಲ್ಲ. ನೋಡ. Guarantee central government standing. To whom it is, sir?
Please, Bill.
To whom it was?
Third respondent, please. Bill.
Respond number 2 ಗೆ.
Yes, three. So 3 alla, 2, Chief Electoral Officer. Because 3 is under 2, please, Milord.
How do you serve this?
By hand, please, Milord.
Where is the receipt?
So that is the record.
This is the one they have given, no?
So we have filed it before the court for having that filed. This is the acknowledgement. It is in the court records, please, Milord.
Where is the acknowledgement?
No, see, it is in the court records, please, Milord. The memo we have filed stating that it is served.
Serve ಮಾಡಿದೀನಿ ಅಂತ ಮೆಮೊ ಹಾಕಿದ್ದೀರಾ.
Yes, that is there. Our acknowledgement, original, we have submitted to the court, please, Milord.
ಎಲ್ಲಿದೆ ಅದು?
That is in the court file, please, Milord. Is to be traced.
This one. On 13/6/2024, we have passed the following order. Mr. Reddy, the council appearing for the appellant submits that in terms of the said order, the video letter dated 18/6/2024. My copy of the appeal has been served on the electoral officer, Chief Electoral Officer, Bangalore. We find there is no Bangalore. Bangalore. So we find there is no appearance for respondent number 2 and 3. Though respondent number 1 and 4 are represented through so and so. Mr. Appropriate, shall we let a notice be issued to?
Central Government Standing Council. ಅಲ್ಲ respond number 2 is by ಇದಾ?
Who according to the learner council for 1 and 4 are being represented, should be represented by the standing council, Central Government Standing Council.
Yes.
Accordingly, notice be issued to the Central Government Standing Council, returnable after 2 weeks. Give me date after 2 weeks.
25/7. 25/7.
The assembly of employees. They're handing over the union machines, those. These people. You see this?
Point number 3 is a temporary post, please, my lord.
I know you're
Yes.
right. That's the reason we have called the Central Standing Council.
Obliged. In fact, at the time of hearing for preliminary hearing, the learned judge, please, my lord, single judge. So at the time of preliminary hearing itself, it was about to be quashed, please, my lord. It is off the record I am submitting, please, my lord. And it was about to be quashed. But since it was election was an hearing, the learned AG came and requested the honorable court actually to make some interim arrangement. Therefore, some interim arrangement has been made. Only 50% of the premises has to be given to them and 50% is to be handed over to us. That's what it has been made. Interim order may be further. So it is like that, said. And at the time of hearing of this writ petition also, please, my lord, the learned judge was pleased to ask me what remains there. Then I said that aftermath, some acts, deeds and things have taken place on account of this order. Therefore, we are aggrieved by that, not on account of the utilization of the premises, we said. Then at that time, so you are not made such prayer. Then it has made me to file the application for amendment, please. Circumstances.
Thank you.
Obliged.
But I appear for the. They should be there. They should be there. Let's see. This time in this order and in the simply doing it so which only for polling material. But they say it's the industrial version. They say for polling.
Obliged.
Thank you.
Obliged.
But I appear for the respondent.
Yes.
I appear for the appellant.
It's 27 number.
So the matter where I had raised an objection regarding maintainability thereafter. ಅದು ಕಸ್ತೂರಿ ಅವ್ರು ಬಂದಿದ್ದು ಅದೇ ಅಲ್ಲಿ ಹೌದು ಕಸ್ತೂರಿ ಅವ್ರು ಬಂದಿದ್ದು ಮೇಂಟೈನಬಿಲಿಟಿ.
Okay. Yes, Mr. Murthy.
This appeal challenges the order of the land single judge passed under the writ petition. Normally, the facts go
proceeds on this basis. Respondent was a contract workman working for the appellant company through his contractor. Normally, in the company, now this is engaged in manufacture of springs for automobiles and various other machinery. They had a contractor by name Vijaya Engineering, thereafter by name one Hemadri Enterprises, thereafter one by name Shakti Enterprises. Now, my lords, he worked under all the three. But in practice, what happens is there is a contractor, he carries out certain job. For some reason, the contract is not renewed with the contractor. Another contractor is appointed by way of an agreement. Most of the workmen go and join the other contractor. That is how, though the contractor changes, contract workmen by and large remain the same. Normally, the contention of the workman has been that he has worked continuously for me, the appellant, through the contractor. Therefore, he should be deemed to be an employee of my company. On this, my lords, the labor court went through the evidence tendered by both the parties and came to the conclusion there is no employer-employee relationship, particularly because registers, attendance register, payment register, everything was produced by the contractors, and it was made known to the labor court that he was really paid by the contractor, he worked for the contractor, which even the workman accepts. And since there is no dispute with regard to facts that they were working for the contractor, the labor court rightly said there is no employer-employee relations and rejected the reference. As against that, writ petition was filed. The learned judge says, since you are engaging in a work of a perennial nature over a period of time, he should be treated to be a company employee. Now, my grievance is the learned judge erred in interfering with the award for the reason that the learned judge feels the third contractor was not even produced. No evidence was let in with regard to the third contractor. There is no evidence that this workman was working with the third contractor. In spite of the third contractor coming before the court, deposing very clearly that this workman was on his rolls, and the workman himself agreeing that he was working with the third contractor also, the learned judge says no evidence is placed on the third contractor, which means he should be treated as a company employee. But if necessary, I take your lordship into the award position, but kindly see the order of the learned single judge. On
Yes.
what basis he has reversed the order of the labor. Kindly see, my lord. The relevant portion of the learned judge, he also refers to all this evidence that was tendered. Kindly see at paragraph 17, page 29.
17, para 17.
Para 17, page 29.
Yes.
In the light of the observations made above, case of the petitioner is examined. It is found that after the agreement period of Vijaya Engineering, he became employee under the respondent, since the respondent does not place any reliance on subsequent contractors to claim that they were employees of the petitioner. Kindly see, my lord, if your lordship sees at page 48, his evidence is there that has been looked into by the labor court. A little later, my lord. 18 may not be relevant because he agrees with me, except saying he refers to object of the ID Act in para 19 and para 20 is a materials and evidence available on record, such as evidence of WW1 to WW3 and evidence of MW2 and WW3, show that no doubt petitioner was initially appointed to judge, but later was continued in the service of the respondent continuously in a perennial nature. There are no materials to show that he was with the later contractors of the respondent. Now the petitioner is resigned from service. Hence he is entitled for only consequential benefit. As a proper adjudication of matter, by giving monetary benefits, I hold it is proper to take rupees 100 per day, which comes to rupees 3,000 per month. It will have to be calculated for 12 years, Date of termination in 1999, and he retired in the year 2011, that is 12 years, which comes to rupees 4,32,000. Interest of 6%, 3,11,000. Total 7,43,000. Same is directed to be paid with the effect of it. Now, my lord, the land judge proceeds on the basis there is no evidence with regard to the other two contractors at all. I may take your lordship into the evidence, into the what the labor court has actually gone into after the evidence was recorded, and kindly see what the labor court says. 43. Page 40. It starts at 39, the relevant portion. Paragraph 13 may be seen, my lords. At page 47. Page 47, paragraph 13.
What is this termination he is talking of?
He is talking of termination. The contractor terminated him from service. Now he says that should be treated as a termination by the company, that is the appellant, because according to him, he should be deemed to be an employee of the appellant.
That's right. Where is if you see page 48,
Milords, yes, Milords.
49,
49.
to issue number 4 and 5 of the labor code.
Yes, Milords.
Party himself admitted he was working under the contractor from time to time. Therefore, party 1 is entered. Where is this admission?
Page 67. 67. Read to. At page 60.
Page 52, claim statement
68,
itself it
Milords.
was stated.
At page 68.
Page?
68, Milords.
58.
paragraph 14.
No, this is your stand.
No, but this cross-examination of, I shall. Cross-examination of workmen. Kindly see 62, my lord, is evidence starts, further evidence of first party by way of affidavit. And 63 is his evidence, 64 is evidence closes. And then at 65, cross-examination starts. Now in that, various aspects with regard to contractor, but 14 is most relevant. In fact, at para 9 is the very beginning, he agrees. In para 9 at page 65, he says, I do not know if the second party may interest in civil works concerning maintenance and housekeeping to contractor on payment basis. There was a concern called Vijaya Engineering. Thereafter, Hemadri came as a contractor. Thereafter, Shiv Shakti Enterprises came as a contractor. I do not know if works concerning civil works, so it's a maintenance, housekeeping, interest to Vijaya Engineering, and thereafter Hemadri, and finally to Shiva Shakti Enterprises. Then it is true that I approached Vijaya Engineering for an employment. It is true that Vijaya Engineering gave me an appointment. It is true that I joined the services under the hands
So
of
you
Vijaya.
You see page 67.
My lords, 67.
That's right. 67, see this question and answer.
It is these three contractors used to pay monthly wages to you as and when they took over the charge. Concerned person of the contractor used to come to the department where I was rendering service and used to pay my monthly salary. What else is required, my lord? He himself agreed. A person of the contractor came and gave me salary in all the three cases, with all the three contractors.
Lord, my, yes,
Yes,
ma'am. I'll convince me. Lord, your Lordship, kindly have a look at my claim statement, my Lord, page 52.
Page
52. My case before the trial court was, the contractors were name lending contractors. I was working in the hardening section of this company, which is a perennial job in nature, which is not a casual job, which cannot be entrusted to a contractor. Only housekeeping job can be entrusted to a contractor. The management appeared before the labor court and tried to project a case that I was working in housekeeping section. For that, my lord, I had produced the report to show that I was working in the hardening section. It is in the perennial nature of the job. And my entire case before the labor court was, it was a sham contract. It was a camouflage. The only contractor were name lending. Therefore, in the pleading itself, I have stated I was appointed through contractors. But even the contractors have changed.
Where is the finding of the labor code? It's a sham and camouflage.
My lord, that labor code has not considered that, and learned single judge has considered this. My lord, the reasonings are given. My lord, I have examined 3 witnesses. Your Lordship may kindly see. I have examined 2 employees, and I have marked, Lord, the documents in support of my case. Lord, kindly have a look at the documents which
Let's
have.
see first your case of sham and camouflage.
Yes, my lord.
Where have you set up?
My lord, kindly have a look at page 52, my lord. Claim statement. Second para.
52.
52. It starts at second para starts at page 51. The first party workman is a workman appointed in the year 1981 as operator in the hardening department of the second party. The second party is a company manufacturing springs for automobile industries. The first party was appointed by the second party company as operator. but the salary for the first party was paid through one contractor by name Vijaya at the rate of ₹7 per day.
Now just hold on.
Yes, ma'am.
So this you accept it is being paid through contract?
Yes, ma'am.
Did you challenge that particular process?
My lord, that is what I have challenged here. That's what I have challenged. Further, my lord.
No, but
Yes.
this is a happening
Yes.
in 1981.
Later, my lord, I have pleaded later. The first party was appointed in the hardening section of the factory. The hardening the springs is a part of manufacturing process. The work which was allotted to the first party is of perennial in nature. Since then, the first party is working in the same section, and presently the first party was paid salary of ₹90 per day. The salary was paid to the first party directly by the second party in the name of the contractor. Though the first party was paid the salary through a contractor by name Vijaya, subsequently the contracts were changed on several occasions. After Vijaya Engineering, Hemadri was appointed as contractor. Thereafter, Shivashakti Enterprises was appointed as contractor. It is submitted that all these contractors are relatives of the directors of the company. The work allotted to the first party is not seasonal one. The nature of the work is of permanent in nature. The second party has paid contribution to the employees' provident fund to the company's account in the name of the first party. The first party was registered with the Employee State Insurance Corporation. Things standing thus, on 13/11/99, the first party went to the work as usual. To the surprise of the attendance register, it is mentioned was as not allowed. On inquiry, the first party came to know that the second party management has terminated the services of the first party. No order is passed in this regard. No inquiry was held. Thereafter, I have stated. Kindly have a look at the counter of the second party management.
Who was second party?
Company.
Who was first?
First party is the employee. Employee. Next page, you will get page number 55.
But tell us one thing, were you not required to implead the contractors?
My case itself, they have a
very sham and camouflage.
For this reason, I would say it is sham and camouflage. Because
you will plead it and prove it.
Yes, my lord. I have.
See, that's what the Supreme Court has.
Yes, my lord. I have pleaded that.
Where is that?
I have pleaded that the hardening department is a perennial job, and the contractors were name lending. My lord, kindly have a look at the counter.
See, sham and camouflage means effectively the contractors are alter ego of the management.
Yes.
That's what you have to say. Look here, it's like piercing a wheel. Ultimately, who is behind is the management.
Yes. Yes,
so
yes.
It is, so giving a color of contractual appointment is nothing but a sham and camouflage. But perennial, very well, it's perennial. Where is the bar that perennial cannot be outsourced? There is no bar. There is no bar under section 10 also of this nature cannot be, carried out through the process of contract labor. There is no bar. There is no prohibition. That's right. If that be so, then the test being cam and camouflage, unless it is, foundation laid down.
I agree.
Government's made, and then you say it. Because, minded, there is a judgment of the Supreme Court which says that if you are working in the management, the initial management like this, but your services have been transferred to a contractor, then you are required to challenge that particular action of the management to shift you to the contractor, saying that that is bad. For all purposes, my appointment is this management and I should continue that. But you never challenges the payment of salary also from the contractor. See, what is the test? Test is who is paying the salary, who has the control insofar as your working is concerned. That's the test. If these two tests are fulfilled, then whether it should necessarily follow that you are an employee of the main management, that is the opposite party too.
Can you please share Sudeep's time sheet there?
Lord, here, the evidence was led to say that, my lord, the control was with the management because I was signing the main attendance of the hardening department. I have produced the attendance register to show that I was working in hardening section.
We'll tell you.
Yes.
This take down this judgment. International Airport Authority. International Airport Justice. Just ask him to type this in the Google. National Airport Authority of India versus National Google. Just put international airport. Okay. He said national, international versus international airport. Justice Ravindra. International Airports Authority of India versus International Airport. 1 minute. What is this? Just 1 minute. See, there is a judgment of the Supreme Court. Justice Ravindran has given this judgment. And you must look into this.
APS certificate. APS certificate.
No. This is International Airport Authority of India versus International Air Cargo Workers Union and another. This explains the law in these facts. What the Supreme Court has held. See, once it is proved, if it is subject to what you say.
Yes.
That they are not the employees of the second party. Then the consequence is this, there cannot be any absorption. That's right. But if based on an evidence, such a conclusion could not have been arrived at, also the consequence would be that you are not. So in any case, in your case, you did not make even the contractors a party.
Yes, I have not made that.
And they are very necessary and a proper party for the reason, who will vouch that who was paying the salary? Although you have in your deposition said that salary is being paid by them.
Yes.
If that salary is being paid, then will it not mean that you were actually the employees of the contractor? That's the test. Who is paying the salary?
Lord, here obviously in all cases like this, naturally they would be paying salary through the contractors. Therefore, my lord, even in the test which was initially laid on in Air India. The nature of the work is the test per day.
May not be necessary. Why not? Today, housekeeping, today, data entry operation, today, everything, most of the things. are
Any
being
casual
outsourced.
work, yes, Milord, it is
Being
permitted.
outsourced. Is being outsourced.
And-
To say that if this work is there, this is perennial in nature, would not have been outsourced, possibly.
Milord, here, in this case, what transpired, he is an operator in the hardening department. That fact is not denied in the counter. Therefore, my submission is, Milord, if it is he was an operator for 20 years in the hardening department and continuously changing the contractors, and they made an effort to say that he made a request that he has rejected.
But then tell us, why didn't you challenge the payment of salary by the contractor?
What?
You're right, getting the
Yes.
point.
Yes,
Who was paying you salary? In terms of your deposition, the salary is being paid by the contractor. You should said what locus you have to give me salary. My salary should come from the second party
yes.
because I am an employee of second party. This happened in 1981 till 1999 when you continue.
20.
How would you answer that?
Lord, my submission is, Lord, he was only at the receiving end. If he had questioned the payment of salary, he would have been out of service.
No, you can't say both the
No, no,
things.
that is the situation of a labor, Lord. That's,
But you are a technical hand. It's not, you only now said you are not a casual labor in that sense.
no, he was not he was an operator. He was an operator. He was an operator. That is exactly the case.
That's what the Supreme Court holds. Interestingly, in this matter, these were ground handling cargo employees,
No, no, yes, no. In airport, yes.
in this
yes.
judgment. What you see in the airport. Initially, it appears they were part of the international airport, but subsequently they were shifted under the contractor. And they continued under the contractor. The Supreme Court holds that action should have been challenged. Once that is proved that you are working under the contractor, then the Supreme Court says sham and camouflage need to be pleaded and proved. We don't know whether you have pleaded also that. That's one. Saying that it is perennial nature of job, that may not necessarily hold that it is a sham and camouflage.
No, it is one of the factors.
Pardon?
It is one of the factors.
Very well, it can be one.
One of
It's a
the-
perennial nature. Instead of taking regular employees by them, they have outsourced it. You can argue that. So, but the fact remains, the salary having been paid by the contractor, how would you come out?
Lord, definitely he has not challenged that. But my submission is, Lord, the fact that he was working in hardening department was not denied. But the management themselves have produced one of the contractor to say that they were paying the salary, and that is my case also, because I stated in my pleading itself, they named the Vijay Engineering in the beginning and appointed through him and continued later. The contractors have changed, but I still continue to work for 20 years.
Under different contract.
Under different contract. But not on my request, it is on the request arrangement with the management. But the fact that he was continued through under 3 different contractors without his request, and he was working in the permanent section and signing the attendance of the hardening section, proves that, Milord, he was.
This also has been considered by the Supreme Court.
Yes.
If the person is signing the attendance register in the second party, this is only because ultimately second party has outsourced it. He wants, the second party must know that every person is coming and doing the job for which the attendance is put. And the Supreme Court has said, if I have outsourced, like assume this court outsourced the housekeeping, this administrative in charge of the High Court will see, look here, all people are coming to do the work. To that extent, there is a supervisory, even by the court, may not be by the contractor.
Yes.
To that extent, because ultimately the court is paying for the work they are doing it. So to that extent, that supervision is necessary.
Extracting the work.
Extracting the work.
But here, Milord, the PF is paid through the company. ESI is paid through the company. But in the real case of the contractors, Milord, the contractor is bound to pay all those things.
ESI was paid by the company.
It is based on the contractual terms
which was entered by the second party with the contract. If the contract between them say that you directly pay it to the PF account of these employees, then is it bar?
No, I am not saying, I am not saying it is barred because they can pay.
Correct.
But it shows the intention of the party.
No, but there is an obligation on the principal employer.
There is an obligation.
On the principal.
That is why when they engage the contractors, they will first see whether he is registered in ESI and PF.
That's right.
That will be the one of the conditions.
Suppose the contractor doesn't pay, the obligation.
Then obligation will be on the employer.
To ensure those dues are paid.
Yes. Now they will see only, they definitely there will be a clause in the agreement with the management. With the contractor.
What does the learner single judge holds now?
Learner single judge, you Lakshmi kindly see. Page number, para 14 onwards. Substantiating his submission, learner counsel placed reliance on the evidence of WW2 and WW3, who are N. Shankaraya and P. Krishna Reddy.
Which page you are reading?
Page 24, para 14. Substantiating his submission, learned counsel placed reliance on evidence of WW2 and WW3, who are N. Shankaraya and P. Krishna Reddy, have stated that the petitioner was appointed in the hardening department in the year 1981 as an operator. He was doing his work in a perennial nature. Without hardening department, the manufacturing process cannot be completed. The documents marked as exhibit W1 to W3, PF annual statements, W4 ESI card, W11 PF statement, W15 copy of the PF settlement, a statement which showed the production directly made by the respondent. This further shows that after Vijaya engineering period was completed, the respondent has taken the petitioner to make production. The specific defense has not been taken by the respondents, though it is submitted under the subsection 2(9) of ESI Act and section 41 of ESI Act and section 2F of EPF, section 32(1), 2 and 3 of the Act, which initially had made the employer to contribute the ESI contribution. The principal employer shall pay in respect of every employee, whether directly employed by or through an immediate employer, both the employer's contribution and employee's contribution. Therefore, it is to be seen whether services of the petitioner were with the respondent or with the contractor. It could be seen from the evidence of WW2 and WW3. WW2 N. Shankaraya has deposed, I know Mallikarjuna, the first party herein. He was working in the hardening department as operator. He was working from 1981 as operator in 714C hardening department. The hardening department is our neighbor department. The nature of the work he was doing was a perennial one. Without hardening department, the manufacturing process cannot be completed. He had never worked in Garebavi Palya branch. He was working without any break to the duty. 1 second, I'll pause here. They produced the contractor to say that he was not working in the main plant. He was working in Garebavi Palya plant. It was a different unit. Not that they were not able to prove that. On similar terms, WW3 P. Krishna Reddy deposed. Since 1981, he was working in the hardening department in a perennial nature for the purpose of production. WW2 in his cross-examination has deposed that. I do not know that first party was working under a contractor. First party was working in hardening department. Management was paying salary to the first party.
Did they produce any contract with these contractors?
No.
They did not.
Only witness.
Only witness.
Only witness.
And salary slip.
Salary slip.
What is the evidence they produced to pay that the contractors were paying the salary?
Not one book, there is some signature on that. That's all.
Is it here on?
It is annexed to the, it is produced as.
Show us.
I'll show. Exhibit M6. Trial court record is placed.
Is trial court record here?
It only says copy of payment register.
So finally, this learner single judge He grants what kind of a relief? Evidence does. But later continuing the service, they are no needed to show even. Yes. So the single judge has granted the relief post 1999 till you attain the age of superannuation.
Yes. Only 100 rupees per day.
Hmm?
100 rupees, sorry, per month.
No,
Sorry, 100 rupees per day, 3,000 rupees per month.
Per day.
Per-
Mr. Moti, did you produce the contract with the contractors?
Contract with the contractors, but
See, what is the basis for you to say that you have outsourced the work?
no, Millards, that is
Not produced.
no, Millards, there was nothing on record because pay slips were there before the court under which they were paid. But the
He
learned
said the
judge felt
register
100
was there,
rupees
the
per day.
salary payment register was there.
Payment register was there, Millards, which are all marked also. However, the learned single judge thought 100 rupees, maybe the yardstick.
Yes, then if in the absence of that, what is the basis except the fact that the salary was being paid by a third entity or a third person? That's all. To say that you had engaged a contractor, outsourced the work, that can't be proved. In the absence of any contract, surely an appointment of a contractor presupposes an agreement that you have outsourced the work. And there is an obligation put on the contractor to pay all labor dues, everything with respect to the contract labor. And according to him, the ESI and PAF contribution were made by you. How would you answer that? Can you hear us?
Millards, I am not able to hear, Millards.
No, just we want to now, can you hear us?
Yes, Millards, now I can hear.
Yeah. So no, we want to know, you have not produced any contract with the contractor. Your contract with the contractor outsourcing the work.
Yes, Millards.
What has been produced is only according to the council, the salary payment register.
Yes, Millards.
It is his case also, even PF and ESI contribution was being made by you.
Millards, that is my statutory requirement, Millards.
That's right.
Kindly see, Millards, the provisions.
No,
in
that's
the-
right. That even single judge has also said so. But how, what is the best evidence for you to say that this, you have outsourced the work to the contractor?
The fact that contractor comes and gives evidence, my lord, the fact that the workman says, I approach the contractor for employment and the contractor gives him employment, he sends him to me. All this is, it need not be in writing. After all, it is by oral. A contractor comes, I tell him carry out this job. He brings his people and carries out the job. And the workmen never disputed that there is no contract at all. If that was so, they could have clearly said there is no contract at all. How can I be an employee of contractor? How can contractor pay me? They never disputed any of these things. On the other hand, in the claim statement, they have said the contractors are relatives of the owner, something to that effect. But the workmen also accept that they were contractors. And so far as they are concerned, it is the salary which is of utmost importance, which was being paid by the contractor. Now it's too late in the
Yes.
day for them to say there were no contractors.
Hmm. In fact, the reference has been made to international airport.
Yes, but I have produced the judgment also, my lord.
Yes.
To both international airport I have produced. I have produced Bengal Nagpur cotton mills case and Ranbir Singh and others. I have produced all the judgments. Your Lordship may kindly see my list of authorities from Bharat Heavy Electricals. I have produced each one of the judgment where all that has been said is who appoints, who pays salary, who has the power to send him to work, who
That's
has the
right.
power to dismiss him. If these four are satisfied, then you cannot challenge about having been a contract workman. Now, for example, the Supreme Court says, Milord, may I make one submission, Milord? For a long time, the Supreme Court did not give any importance to the second part of the definition of contractor. Contractor means a person who agrees to produce a given result or who supplies labor. Or who
Yes.
supplies labor was virtually eliminated, omitted. Supreme Court says no for a long time, right up to the electricity judgment. But thereafter, from the last about, I would say, about 6-7 years, there has been a change in the thinking of the apex court. There are 5 judgments, all of which say that these 4 criteria are important to determine whether it's a contract labor or otherwise. Now, in my case, it is the fact that workman himself says, I went to the contractor appointed me, contractor paid salary to me. So now how do I come in the picture? I have to remit contribution under ESA and PF because I am statutorily bound to do so under the definition of employee, under the Provident Fund Act Section 2F, and also under the definition of employee under Section 29 of the ESA Act. It says employee means any person employed directly or through by a contractor. Therefore, there is a specific section and the rule paragraph which says in the first instance, it is the company principal employer who should pay contribution of both his employees, contractor's employees, and the contribution of the contractor's employee, and then get it reimbursed. There is a section in that. Therefore, I have discharged my obligation. The only thing for consideration, in my opinion, my lords, subject to what your lordship feels, is whether a workman who has been working under a contractor from time to time, contractors change, but the company remains the same. Can, within the framework of law, any fault could be found?
Yes.
That's the only question.
Hmm. Yes, Mr. Naik.
Lord, page 81, the contractor's evidence.
Yeah, just before that, can you come to page 28?
Yes. Yes, please. Control and supervision.
Hmm.
Not regarding this.
Supervision, control of principal, but that would not make the work a direct employee of the principal employer. If the salary is paid by a contractor, if the right to regulate employment is with the contractor and the ultimate supervision, principal only controls and directs work to be done by contractor. When such labor is assigned, allotted, sent to him, but it is not the contractor as employer who chooses whether the work is to be assigned. Principal employer used to otherwise. In short, worker being the employer of the contract, the ultimate supervision controls it.
Lord, in order to support this, Lord, they have examined the contractor. Kindly have a look at the evidence of the contractor. Lord. 2 lines I will read from.
Which page?
Page 81.
81.
Yes.
Yes.
I am the first para, my lord. He is Mr. Rabjendran, affidavit, first para I am reading. I am the proprietor of Shri Shivashakti Enterprises, having undertaken the housekeeping and allied services like civil and cleaning and maintenance work of the second party. Lord, it is nowhere the case of the management also that I was working in cleaning and housekeeping. His job was restricted to, according to him, was cleaning and housekeeping. I was in the hardening section. It is altogether a different section where, my lord, he had no control.
Okay.
This evidence will not help the management. And he says, I have taken the contract in the main plant and Garibay both. In order to carry out the contractual work, I have engaged my laborers. I have selected the laborers according to my choice. Here, my lord, in the cross-examination, he admits that this petitioner was engaged even prior to his taking the contract. And he was working in the main plant, not under the Garibay
So
plant.
he is Shiva Shakti, no?
Yes, my lord.
Who was the first Vijaya?
Vijaya. Vijaya, thereafter Hemadri, thereafter Shivashakti is the third contractor.
How does this is going to help you?
Malad, ultimately, the management has to produce that they have engaged a contractor and it is a genuine contractor for this purpose. But according to their own evidence, this contractor was engaged for housekeeping and allied services of civil and cleaning. Malad, they have not engaged any contractor to work in the hardening section. There is no evidence from their side.
Will that be a relevant criteria? Tell us one thing. When you have accepted who is paying the salary.
Malad, initially it was Vijay. That is my case because
That's
I cannot go
Vijaya,
beyond
so
that. Yes.
Don't deny Shiva Shakti also.
Yes.
Then, see, that's the test. Who has the power, who has the supervision, who has the power to dismiss you? That's the test.
Malad, I'll put it this way. That when they are the name lenders, contractors are the name lenders. That is exactly my case.
Contractors are the?
Only name lending contractors.
You can argue that, but how would that really help you?
Malad, if I prove that in order to avoid the regular labor law, to exploit it, they use the contractors. Malad, definitely.
But he says he is registered under the contract labor abolition.
He is registered for, and his engagement is only for keeping the civil and cleaning and maintenance work. Definitely hardening section was not given to him.
What are your qualifications?
Malad, ITA operator. He is machine operator.
How much you were being paid?
That time, according to him, initially he joined it for 7 rupees. Then at the time of working, he was paid around 99 also. And he was terminated.
For minimum wages?
That time, Lord, it is
81.
91. Sorry, 99.
No, 99 terminated.
Yes.
81 you joined according
I
to
don't know. That
it
time.
says 7 rupees.
7 rupees.
You have any judgments in support? Show us.
Not only on the judgment of Air India, sorry, Steel Authority of India, not where in page number para 125, para 5.
Yes.
I relied upon that para and built up my case.
It is Steel Authority, no?
Yes.
Para 125.
125.
What does it say?
2001 7 SCC. Not once the contract is abolished, then we will have to approach the labor court for proving that I am the employee of the.
That you have approached, but how sale is helping you?
Not only to the extent of to prove that it is a perennial nature of the work and which was.
No, which
outsourced.
paragraph says perennial nature of work would denote sham and camouflage?
Once it is prohibited.
Pardon?
Once it is prohibited under section 10.
It's not a case of prohibition. Then
it's not a case.
You're right. It's actually, that's the law. If it
That's
is a prohibition in any case, then it is perennial nature. But that's not your case, no?
APSRTC versus G. Srinivas Reddy. I brought only one set of judgment. It is only to show that, my lord, the labor court has power to lift the weight,
Labor court has power to?
declare that it is a sham contract.
Oh, yes, even the Supreme Court says so.
Yes,
Supreme Court says so. You have to set up that case before that court only, not before the High Court.
no, I have set up the case, my lord, the trial court,
But we have not seen those words, sham and camouflage.
I have stated. I've stated like this, my lord. The second party has adopted unfair labor practice. It has appointed number of employees for the perennial nature of work through contractors. The contractors are being changed from time to time, but the employees are continued.
But Mr. Nayak,
Yes,
perennial nature would only come if there is a prohibition.
Yes,
But that's not your case.
I'll just, on this issue, my lord, I'll go through that judgment and I'll make a submission tomorrow.
Which one?
The power of the labor court. Power of the labor court to be in the absence of prohibition.
No, that's settled, Mr. Nayak. It's only the power of the labor court,
Yes,
no one else. Even 226 also is barred. It's a disputed question of fact and law. So that need to be is the labor court.
my lord, while exercising power under 226 in the matter arising out of labor court, my lord, the 11A can be 11 can be exercised by this honorable court also.
We have our own reservation on that. We have 226, 11A jurisdiction cannot be.
My lord, it is, I'll convince you. 11A
But-
jurisdiction.
But we are not concerned with that, na?
Yeah.
Shall we do? Anything else you want to argue? That's all.
That's it.
We'll reserve it. Thank you. Heard the counsel for the parties.
Much obliged, Lord.
Judgment reserved. This. Thank you. Yes.
Lord, there are two appeals, my lord, arising out of common order passed. Lord, I am a power utility and a distribution licensee for a part of the state of Karnataka, my lord. And I'm a deemed licensee under section 14 of Electricity Act 2003. One of the proviso to section 14 says, if there is a license which is operating prior to the introduction of the Act from 10/6/2003, I am a deemed licensee. Under that, my lord, I am a deemed licensee. I am in the business of distribution of electricity. My lord, I function under the control of the regulator. And the power of the regulator is found under Section 86 of the Electricity Act of 2003.
Yes.
Lord, the functions of the regulator includes fixing of tariff at which I purchase, also the rate at which I sell, and also the contracts which I enter into with any generating company. It has to be approved by the commission. I can only enter into a contract and procure power as approved by the state commissions or central commission, Lord, depending on the kind of transaction. Now, Lord, there is also provision which empowers the commission to give certain incentives for particular sectors such as non-conventional energy sources and other sectors, identified sectors. That obligation is cast on the state commission by Section 86(1)(e) to promote cogeneration and generation of electricity from renewable sources. Now, in this background, state has issued policies which is provided for under Section 108, and there is a renewable energy policy which is issued by the government, and that is taken note of by the commission while passing various guidelines, orders, etc. Now, one such action under these provisions is to encourage solar rooftop units. Now, the whole concept is that if there is including this building also has solar panels, which basically the entire building is connected to the state grid also. There is generation of power which is taking place from the solar rooftop system which is installed. The generation which is taking place in this building is first of all consumed in the building itself. It caters to the need of the person who has installed the rooftop unit. Then there is a bidirectional meter. Depending on, for example, on a Sunday, if there is no consumption in this particular building, then the energy which is being generated gets fed into the grid. So at the end of the month, when the billing is seen, it is net of what energy was imported and what was exported. Net of that will be the bill for which a consumer pays for. And if the net of it is a situation where the consumer has fed more energy into the grid than he has consumed, that is paid for at a particular tariff. Now, in this case, the question is as to what is that tariff that these writ petitioners are entitled to. The whole issue was the policy said you have to install the system within a period of 180 days. That is there in the policy itself. Now, when the issue came before the commission, by mistake, instead of mentioning 180 days, they mentioned it as a year instead of 6 months. Later, it was realized that it was a mistake because the policy itself said 180 days for an existing rooftop. In case of a building which was supposed to come up, the policy provided for 1 year. So in few cases, there was a mistake by the commission in mentioning the date in the approval that was granted. When this was realized, the commission issued a notice to say that the policy says 180 days. Your approval mistakenly says that it is more than that. Therefore, this needs to be reversed and you are governed by a particular tariff order and not the earlier order. That is challenged in a review. There is a detailed order by the commission. It has review power under section 94. There's a detailed review order. Now, the original order passed by the commission and the order passed in the review, those are challenged in a writ petition before this honorable court. And the writ court has allowed the petition and restored the position so far as tariff is concerned prior to the order of the commission reducing the tariff and directing us to adhere to the subsequent tariff order passed by the commission on 2/5/2016. So this is the background, my lord, of the present list. Now, my lord, kindly see a few documents, my lord, to appreciate, my lord, the contentions. There is a policy, my lord, policy of the state of Karnataka. This is a 2014 to 21 policy.
File your submissions on this.
Yes.
Because ultimate direction is this power purchase agreements need to be adhered to. That's the, now what are the relevant clauses in the power purchase agreement?
I can file, my lord. So it's short synopsis.
File your synopsis submission so that we can have a better perspective of the.
We'll do that.
What is the difference between your tariff and the power purchase agreement agreed to?
Lord, original tariff was 9.56. The revised tariff as per the order, my lord, there is detailed reasons for it is 5.26. 20. Lord, ultimately, my lord, this is a project for the PPS for 25 years. Now, my lord, I will point out, my lord, the process of fixation of tariff. Why that difference happened, my lord, is if my lord could see only 2 pages, I will file detailed synopsis. In the tariff orders which are passed, if you kindly turn to page 53 of the appeal memo in appeal 95, this is the tariff order of 10th of October 2013. Lord, at page 59, bottom of that page, there's a table. The capital cost for megawatt scale, this is 1 megawatt capacity. So megawatt scale power solar PV photovoltaic plant is 8.30 crores per megawatt. This was the cost as on the 10th of October 2013. Lord, very drastic change happened. Kindly now turn to Lord page 91, Annexure L. In that page, at page 101, the cost per megawatt has gone down from 8.30 to 5.30 per megawatt. 5 crores 30 lakhs per megawatt. That's the difference because of change in the technology, cost going down, etc. Therefore, there was a reduction in the cost. This is a detailed analysis of capital cost, return on equity, plant load factor, availability of the plant, etc., etc. All that is taken into reckoning to come to a conclusion as to what the tariff should be. Now, Lord, this is the background in which the commission said, you have installed and commissioned this particular solar rooftop plant at a particular point in time when you had incurred this 5.30 crores per megawatt as the cost and not 8.30. Ultimately, my lord, the whole idea is in about 9 years' time, the entire cost of the project should be recovered by the entrepreneur who's putting up that plant. Now, my lord, with the reduced cost of capital cost, if I pay him at 9.26, my lord, within 4 years he recovers. Then the plant for the next about 21 years is free for him. But I continue to pay at 9 rupees and odd. That will be the implication so far as the difference in tariff is concerned. That is what has been considered by the commission, my lord. I will file a short synopsis and take the honorable court through.
But was this aspect looked into by the commission?
Yes, ma'am. There is a detailed review order at page 125, where these contentions were raised. Lord, in fact, because these orders are appealable under 111, Lord, I had taken a preliminary objection to say that this is a tariff exercise. If you are aggrieved, you should go to appellate tribunal for electricity under 111 because the appeal is available. In fact, this honorable court has had an occasion to, Lord, consider as to the effect of availability of a alternate remedy. That was my first contention in my objection statement and also before the learned single judge. That has not been considered by the learned single judge at all. And on the issue of promissory estoppel, my lord, I have been directed to pay the higher tariff. That's the only ground on which, my lord.
On that agreement.
Based on the commission's, Lord, commission said wrongly, Lord, which commission realized later, commission, instead of saying that you have to implement this project in 180 days, in case of an existing rooftop, said you do it in a year's time. So I have been held on to that mistake by the commission, which the commission tried to undo by issuing notice, hearing, passing an order, etc. To say that once you have told them that it is 12 months, you have to adhere to that, and you cannot wriggle out of a stipulation which you have made in your own approval of the power purchase agreement. Because this is, if the project is below 1 megawatt, it does not go to commission for approval because there is a deemed approval for such installation. Because this was 1 megawatt, it had to go. The mistake arose because of the mentioning of that date in the approval.
Okay. Governor Council for the party shall file the written submissions along with the judgment they wish to rely upon. This 1 week before the next date of it. Somewhere in August or first week.
Any earlier date, my lord? No.
So the board is such, it's difficult.
Very well, very well, my lord. I understand. I was just wondering, my lord, whether it is possible. Otherwise, my lord, I understand that pressure is.
Thank you.
That is, my lord.
28 and 29, both are.
Yeah, both, my lord, same issue. It's a common order passed in both cases.
My lord, instead of 8th, can it be 7th, my lord? Instead of 8th, can it be 7th? Or 9th?
Not possible, Mr. Ola. We have fixed some batch matters on that.
Or on 9th, my lord, because 8th, I have some difficulty. That's all.
Not an issue. If you are-
Or even 6th, my lord, I have no problem.
That suits you on 8th.
8th,
No,
Eight.
you said 8th.
9th, my lord, 9th.
9th is
Very well.
9th August.
Please, ma'am. Grateful. We'll also prepare, my lord, and file a short synopsis.
In fact, we want both of you.
We'll do that. Judgments also. I'll prepare and give it to you.
It's all, man. Get up.
Nobody wants to.